I don't have a gavel right here. I would like to call the order to the October 5th, 2020 meeting of the Charleston County Board of Zoning and Appeals. Next slide, please. Ms. Working, can you please go over the virtual meeting protocol?
Yes, staff will control the slides displayed throughout the meeting. Applicants and members of the public must be sworn in before speaking for the first time. They should state their full name and current address for the record. Only attendees who have registered to speak before the deadline, 12 p.m. on 8/31, may speak during the meeting. Applicants and the representative for the public hearing cases are registered to speak. Video and microphone have been disabled for all attendees. Attendees will only be given the capability to speak when they're called on by the BZA secretary or chair. If you submitted a request to speak on a case before the deadline, staff will call your name when it is your turn to speak and will enable your microphone. Your microphone will be disabled after you're done speaking. Chat has been disabled for everyone. Board members who need to recuse themselves will not participate in discussion or deliberation and will not vote. And just to go back to one, the deadline was today at noon. Sorry about that. And lastly, this meeting is being recorded.
Ms. Working, can you please call the roll for the BZA members and introduce and swear in all the Charleston County BZA members and staff that are present today?
Okay. Mr. Ray?
Present.
Ms. Lechner?
Present.
Ms. Allison? Sorry.
Present.
Okay. Mr. Boykin?
Present.
Mr. Freeman?
Present.
Mr. Goldstein?
Present.
Mr. McConnell?
Here.
And Mr. Nelson?
Present.
The attorney for the BZA, Mr. Calvin Hegee?
Present.
And Mr. Woodall is the BZA member that is absent today. The Charleston.
Next.
Oh, sorry.
Go ahead.
Yeah, the Charleston County zoning and planning staff present for this meeting are Sally Brooks. I think she's on. Joshua Downey.
Here.
Edgar Sada.
Here.
Jennifer Stiles.
Present.
And I'm Jenny, working the secretary for the BZA. At this time, I'm going to swear in the staff that will present testimony or evidence. Staff, please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you.
Next slide, please. Because the hearing tonight is a public fact-finding meeting, we are in compliance with the Freedom of Act and South Carolina Code 6-29-70. 15 days prior to the hearing, an announcement was printed in the Post and Courier. A sign was posted on or near the designated property and was mailed to the applicant, the applicant's representative, the owners of the property within 300 feet, and parties of interest. Persons, organizations, and news media have requested declarations of our meeting and have also been notified. Next slide, please. Board members, the meeting notes of April 31st, 2020, public hearing were mailed to you. Are there any changes? And if so, or if not, may I have a motion to approve and a second?
I so move that we accept the meetings, the notes, agenda. I'll second.
Very good. We have a motion that has been made by Mr. Freeman and seconded by Mr. Borkins. Ms. Working, at this time, let's call the roll and find out who's going to approve it and who's going to deny it, basically.
Mr. Ray?
Yes.
Ms. Lechner?
Oh.
Yes.
Ms. Allison?
Yes.
Mr. Boykin?
Yes.
Mr. Freeman,
Yes.
Mr. Goldstein,
Yes.
Mr. McConnell,
Yes.
and Mr. Nelson.
Yes.
Okay, that's unanimous approval for the August 31st meeting minutes. Summary.
Thank you very much. Next slide, please. The Board of Zoning Appeals is a quasi-judicial body that has final decision-making authority. The Board of Zoning Appeals has authorization to hear and decide appeals on zoning-related matters, where it is alleged there is an error in the order, requirement, decision, or determination made by the administrative official in the administration or the enforcement of any zoning-related regulations. A 2/3 vote of quorum present is required to overturn the decision of the planning directors in appeal. A special exception is an exception issued by the BZA authorizing the particular use in such a location within a zoning district upon demonstrating that such a use complies with all the conditions and standards specified by the BZA, better known as ZELDAR. The BZA must find that the special exception request meets all 6 of the approval criteria of the ordinance in order to grant a special exception. A simple majority is required to grant a special exception. A variance is a relaxation of the BZA of the regulations of the ordinance where such action will not be contrary to the public interest and where, owing to the conditions of a particular piece of property, and note the results of the action or the situation of the applicant, a literal enforcement of the code will result in an unnecessary and undue hardship. In such a variance, this is consistent with section 6-29-800 of the Code of Law of South Carolina and Title 6, Chapter 29. The BZA must find the variance request that meets all 7 of the approval criteria of the ordinance in order to grant the variance. A 2/3 vote of the quorum present is required to grant the variance. Next slide, please. Our purpose tonight is for interested parties to be heard in order to assist the board in gathering evidence pertinent to each case. If a member of the board of the BZA feels a need for further information to clarify a case, the board has the authority to subpoena witnesses. It must be understood that the rules of your neighborhood or subdivision are binding and that we can take no action that would neglect their jurisdiction over your property. In addition to your testimony, our board has been presented written information submitted by staff, by the applicant or the applicant's agent for each case. This information is now considered to be evidence and is entered into the permanent record of this body. It is assumed that it is complete, true, and actual. In addition, we have been presented data assembled by the staff for the purpose of clarifying the location of the applicant's application's effect on the surrounding properties. Our board is empowered to approve with conditions, or deny a special exception or variance request. We are also authorized to defer a case should there be a need to obtain additional information. The BZA's final decision will be mailed within 10 working days of the public hearing. It will be mailed via certified mail to the applicants and via U.S. mail to the neighbors and the community of interest in this list. If an applicant request is approved, the applicant should contact the Charleston County Zoning and Planning Department staff to discuss the next step of the process. Variances and special exceptions granted this evening are valid for 12 months after the meeting. and a 1-year extension may be granted only if the construction or development has commenced or is being diligently pursued. However, an applicant's request is disapproved if the applicant wishes to appeal the decision of this board concerning the case. Appeal must be addressed with the circuit court. South Carolina Code 6-29-820 states that appeal must be filed by the applicant within 30 days after the decision of this board is mailed to them. Failure to file an appeal within the time deprives the court of the jurisdiction to hear this matter. Because this board is a quasi-judicial body, everything said in this meeting must be complete, true, and accurate. All information provided to the BZA is considered evidence. And this board may certify contempt of court if false statements are made, either in writing or orally. Each person who wishes to address the board will be sworn in by the BZA secretary prior to them providing testimony or evidence. Next slide, please. I will now call each case by case number. Staff will present facts pertinent to the case, limited to 5 minutes. I will then call the applicant. The applicant will state his or her name and current address for the record before presenting testimony pertinent to the case, limited to 5 minutes. I would then ask for all those speaking either in support or opposition to the case, and they will follow the same procedure for identifying themselves and are limited to 2 minutes. The applicant will then have a chance to reply to any opposition, limited to 2 minutes. And the BZA will make a motion to close the case to the public. Finally, the BZA will make a motion concerning the application, state specified findings of facts and conclusion of law. Tonight, we have the pleasure of hearing 1 old case and 8, that's right, 8 new business public hearing cases. Next slide, please. Ms. Workin, can you please introduce the old business for the public hearing? Case BZA 04-20-00397.
Yeah, this is the case, the old business case number 1, and Mr. Ray introduced the case number. The applicant property owner is Tori Bolts. Their representative is Brandon Gaskins, Esquire of Moore and Van Allen. The property is located at 6539, 6543, 6555, and 6569 Maybank Highway on Wamala Island. The tax map number is 151000095, and it is located in the Agricultural Preservation AG 15 zoning district. This request is for reconsideration of the BZA's decision made on July 20th, 2020 to approve a variance request to allow an existing gravel and sand shell driveway to remain within the required 35-foot O-storm criticline buffer. The reason for this request is in Zeldar, in Charleston County Zoning and Land Development Regulations Ordinance, otherwise known as Zeldar, Chapter 3, Development Review Procedures, Article 3.7, Site Plan Review, Section 3.71, Applicability, states, the entire site shall be brought into compliance with all applicable ordinance standards at the time of site plan review. In this case, this was a farm road that was then intensified use with the dwelling group and with the short-term rentals. And then Zeldar Chapter 9, Development Standards, Article 9.7, and Section 9.71, Wetlands, Buffers, and Setbacks, requires a 35-foot buffer from the O-storm criticline in the AG 15 zoning district. And then Section 9.72, Prohibited Activities, lists the activities that are prohibited in the buffer area. On this slide shows a photograph provided by the applicant of the existing driveway and the plan the BZA approved on July 20th compared to the site plan that was approved by staff on November 13, 2017. The 2017 site plan shows that the road will be located outside of the 35-foot OSRM critical line buffer. And next slide, please. This is just a zoning map. It's up to y'all if you want me to go through the entire presentation. I know you did see it. And in your packet was the July 20th order and the July 20th minutes, and the entire July 20th packet is in what you received. You also received all comments from the July 20th and August 31st meetings, and comments that were received by noon on October 2nd for this reconsideration. So I'd be happy to go through the whole PowerPoint, or okay. I guess I keep going, Edgar. Sorry. This is just the Zelda requirements that I read earlier. And the aerial, zoomed out aerial. This is the picture from the original posting. We also posted it for this hearing as well. And again, the photo that was provided with some aerials that were provided by the applicant. And the variance criteria, which, you know, we didn't rewrite the report, but there were several additional comments that were received from the public. So the board may approve approval conditions or deny this request tonight. And I would like to mention that the two containers shown in pink, they did obtain permits for those within the last couple of weeks. And then the area that's, oh sorry, that's highlighted in yellow, that's the area that subject of this variance for the critical line. And again, that's the dwelling group plan that was approved on November 13, 2017. And that comparison between the two and the plat. Do you have any questions for staff?
Question.
Okay.
Is it my turn?
Sure.
Okay. I have two questions, one for staff and one for council. The question for staff is, did I hear you correctly just a moment ago? Does the road not encroach upon the 35-foot OCRM buffer, or does it?
So Edgar, if you can go back to the site plan that shows that, yeah, this one's fine. The area shown in yellow does encroach. What we showed was they did have a plan that was prepared, that they got site plan review approval based on that plan, that they were going to construct a road that is outside that would not require a variance.
Okay. And then I have a question for council. Mr. UG, our Rule 20, which governs the motions for reconsideration, doesn't give us a lot of information. In granting the motion for reconsideration, are we conducting a de novo review, just the whole case as if it were never before us? Or do we review our previous action to see if there was some fact or application of law that we overlooked or misapprehended?
Mr. Hughes, are you there? That was from Mr. Hughes.
Did we lose him?
I apologize. I was on mute. No, Mr. Goldstein, it's de novo because it's not an appeal. So the board can review anything that they want.
Okay. Thank you.
You're welcome.
Any other questions for staff, or would you like me to call for the applicant?
Yes, please go ahead and call the applicant.
Okay.
Jenny,
Yes.
I believe you need to call Brandon on that 803 number.
Yes, he's on. Brandon, I just requested that you unmute. Are you unmuted?
I believe so. Can you hear me?
We can hear you. Okay, great. If you can please raise your right hand, I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. Okay, and just state your name and address for the record, please.
Brandon Gaskins, 78 Whitworth Street, Charleston, South Carolina. Good evening, members of the board. Again, my name is Brandon Gaskins and I represent the applicant, Bolt Tree Farm. Because this is the third time that we have been before you on this request, I will try to be brief and I'm happy to answer any questions that you may have. But if you recall, the primary grounds that we were requesting regarding this matter, which involves a very small portion of a gravel and sand shell road that has existed for 20 years, is that actually no variance was required, and that the property as it exists with respect to this matter is in compliance with the ZLDR standards. As Ms. Working stated, the applicable sections are 9.7.1 and 9.7.2. 9.7.2 lists the prohibited activities, which includes any paved or other impervious surfaces. In the position that we took in July and the position that we take now is there is no violation of this provision because the materials of the road are pervious. They are made out of gravel and sand shell, and there are numerous instances in other sections of the ZLDR which defines what is pervious and what is impervious, and those provisions make clear that gravel and sand shell are pervious materials. So when we came before you in July, there appeared to be at least a majority, if not a close to a consensus on that matter. However, I believe that the board decided to grant the variance as an administrative matter to make it easier on staff so we wouldn't have to go back and amend the site plan. But in any case, we believe we have met the criteria for the variance for the reasons outlined previously, and those mostly revolve around the fact that the road has existed for nearly 20 years, if not longer, and that if a variance is not granted, then the applicant will have to move the road, which will obviously cause disturbance of the existing ground and vegetation. And so we believe it is consistent with the purposes of section 9.7.1 to grant the variance and not disturb the natural environment. The additional grounds that have come forward since to oppose the criteria mainly involve potential environmental damage that may occur because of the placement of the road, but those are all speculative. This road has existed for 20 years and there is no record of any environmental harm being done. And so we believe that there are no grounds to reconsider what the board initially approved in July. If you have any questions, I'll be glad to answer them. Thank you.
Very good. Thank you, sir. Does anyone have any questions of the applicant?
I do.
Mr. Goldstein, I recognize your hand, sir.
Thank you. Mr. Chairman, Mr. Gaskins, I think I'm the one who made the motion for reconsideration because I just am a firm believer that everybody ought to have an opportunity to be fully heard. And that's just always been my policy on every case, including this one. However, I have gone through the material carefully that the objecting neighbors have provided us. And I do, and I find that all of it is just a rehash of the arguments we've already been through and which we already took into consideration in making the original motion to grant the variance. And I agree with you. I don't think a variance was necessary for the reasons that you state. However, I did find in the newly submitted material, I did find one new matter that has not been before us. And I don't know, Mr. Gaskins, have you been afforded an opportunity to review the written materials provided to us?
Yes, sir. I believe I have.
Okay. Well, in a letter from Victoria Fowler dated September 28th, 2020, and I know this is difficult since we're all doing it remote, she does point out something that I do not think we discussed the first time around, and I'd like to get your response to it. She says, also, could a criterion be established that this road never be reinforced with pervious materials by this owner or any others if the previous condition is not granted? And I thought that was a pretty good question. What do you say about that? Would your client be willing to an additional condition to the original variance that the road will always be maintained as a sand or what was the other material you call it? Sand shell? And
Sand shell.
yeah, and not reinforced with pervious materials at a later date?
So I'm reluctant to speak on behalf of my client, not having addressed this matter with them, but my initial reaction would be is that the ZLDR would prohibit that in the first place, and it could not be improved with any paved materials unless they sought an additional variance to do that.
I agree with you. So based on that, you would not have any objection to that additional condition being appended. I just thought it might be a way, I mean, it seemed like a legitimate point, and it might be a way to satisfy the objecting neighbors, because the objecting neighbors, they definitely, I mean, as you read through this material, I mean, they definitely have some hostility for your client. You'd agree with that, right?
I would definitely agree with that, Mr. Goldstein.
Okay. And I just thought it might be sort of I mean, I agree with your analysis, but it seemed like maybe that was a way to move the neighbors toward a more harmonious center.
Well, I appreciate the sentiment, and I believe you're probably right, but because of the position that I just took, I really didn't consider it anything worth discussing with my client, as that condition is already imposed by the ZLDR.
Okay, thank you, sir.
Does anyone else have a question for the applicant? Okay. Well, we thank, oh, wait, I got one. Mr. Nelson, the chair recognizes you.
Thank you. Mr. Gaskins, I appreciate your continued patience as we go through this process as well. The one question I have, and this is more for, I guess, refreshing my memory from the previous times that we've heard this case, but in improving the road or the addition of the shell sand that your client put on the road, was there any additional clearing that occurred to widen the road, or any vegetation that was removed in the process of the road improvements of being constructed?
At that particular point in the road, I don't believe so. Now, there was some additional road that was cut that was not inside the buffer where most of the additional gravel and sand shell was installed, and I think there would probably been some vegetation cut there. But at this particular point, I don't believe so.
Okay, that's really the only question that I have, and that was just related to one of the prohibited activities in 9.7.2 that that could cause a problem. But if nothing was cleared in that area, then I tend to think that the improvements to the road are allowed. I don't have any other questions.
Thank you. Does anyone else have a question of the applicant? Okay. Very good.
Okay.
Does anyone have question of staff? Very good. So at this time, we need to have a motion.
We have speakers in line to speak. I
Oh,
was going to
that's right.
put, yeah, I was going to put Mr. Gaskins back on mute. And we have 11 folks signed up to speak in opposition. We don't have anyone in favor unless Mr. Gaskins, if the Bolts are wanting to speak. He might already be muted, but I do not think they want to speak, but okay. So, the first speaker is Elizabeth McCown. So I will find her and get her on. I don't see her on there right now, but we can get back to that one. Let's see, Thomas Heineck. Let's see if he's on here. I don't see him either. Okay. Is Fran and Fred Gunter on here? Just looking to see who's on. I got this list.
Jenny, Miss Skinner has raised her hand. Is it possible that she has a group with,
Yes.
the conference call?
I didn't think about that. Yeah, because I was just looking to go through the list. I know she wanted to speak. She's the 11th person, but I'm just going to go ahead and put her on and we'll figure that out. Because there's a couple of people that are on, but okay. Miss Skinner, are you on?
Yes, and we have several people. We're meeting at the Wadmalaw Community Center because they have bad internet access. So all the people that you called earlier would just like to, they can take their oath and speak under my name if that's okay.
Okay, that will be fine. Okay, so is Elizabeth there?
Hello, can you hear me?
Yes. Okay, Elizabeth, can you please raise your right hand? I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Okay, and then just state your full name and address for the record.
Elizabeth McCown, 652A South Mount Road, Wadmalaw Island, South Carolina. I respectfully request that you reconsider the decision made previously to allow the boat development to use the existing road. I live across Fickling Creek, about a half-mile down as the crow flies. My time's not moving. The existing road is immediately next to the creek bank. It's much closer than it appears in the drawing, and the picture shown on your PowerPoint, it looks like an entrance road. It is not the road in question. I trust that these county ordinances are in place to protect the land and ask that you not put them aside or allow variances for convenience, particularly for commercial use. This road is no longer a farmer's path but one that can be used by multiple vehicles, including delivery and service trucks. So I thank you to reconsider this variance.
Ms. McCown, just please hold tight one moment. Let me find out if anyone of this board has any questions for you. Does any board member have any questions?
Just
Mr. Goldstein.
one technical question. Would you ask the speakers if they're on a speaker phone? Because I'm getting a lot of feedback. It's very difficult to hear.
Very good. So, Ms. Skinner, if you're still there, if you're on speakerphone, we ask that they remove themselves from the speakerphone and speak directly into the phone so that we don't have very much feedback in our system, please.
No, we're not on speaker, but we have two laptops on. That's the problem, so.
I see.
Is
Thank
that
you.
better?
Yeah, you gotta mute one of them.
Does anybody else have a question for Ms. McCown? Thank you so very much for your testimony.
Okay, here.
Ms. Working, who do we have next?
Good afternoon.
Okay, can you please raise your right hand? I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. And then please state your full name and address for the record.
My name is Thomas Heinig. I live on 6542 South Mount Road.
Sir, please tell us why you're here tonight and why we should reconsider or not reconsider, well, reconsider this case.
Sir, and esteemed board, if you take a kayak and paddle out on Fickling Creek, which is where this our homeowners association has its 7 homes, you come right across this road. The road is literally on the creek. It is an old hunting road, and repurposing it to be a service road will impact and damage existing wildlife, which is why we respectfully ask you to reconsider your previous decision. That is all I have to say.
Thank you so very much, sir. Hold tight. Do we have anyone on the board that would like to have a question for this person? Thank you so very much for your time, sir. Ms. Working, who do we have next?
Okay, Fran Gunter, are you there?
Fran.
Okay. Please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. Okay, now state your full name and address for the record.
My name is Frances Gunter, and I live at 2595 South Mount Road, Wadmalaw.
Ms. Gunner, thank you for coming tonight. Please tell this board why we should reconsider.
I believe, as my husband does, that you should reconsider your vote on the variance because of the quality of life in the creek and the close proximity of the road and the OCRM buffer. I believe that the road in that area has been altered, and I believe that the traffic, lots of traffic, and also the runoff from that road would destroy our habitat, marsh migration, and the sea level rise We see it every month. It continues to change. And we have lived there 28 years. We have placed an oyster reef to help preserve our bank on Fickling Creek, which has eroded in less than 3 years, 2 to 3 years. So I'm concerned about the quality of the creek and the habitat that live in there, and the environmental concerns of the road and what type of vehicle is going to be on there. Thank you.
Thank you, Ms. Gunter. Hold tight, please, ma'am. Do we have anybody that has any questions of Ms. Gunter?
Yeah, I do. I got a
Mr.
question.
Goldstein.
Thank you, Mr. Chairman. Ms. Gunter, your concern is about degradation of the creek, and you have addressed it on your property by putting an oyster reef, correct?
Yes.
Okay. Have you ever gone down and called the Bolts and walked down there and asked them if they'd be interested in you're showing them how to put an oyster reef up along the bank of their road to stabilize their bank?
It didn't work.
What didn't work?
The oyster reef.
Okay, so you're telling us, your testimony is that you reached out to the Bolts and offered to assist them with that?
No, I'm telling you that we placed an oyster reef that was recommended to us by a family member who works for NOAA. And we placed it, and the oyster reef, due to the changes in the creek, did not last or hold up.
Okay.
So I don't think that the oyster reef is going to stop what's going to happen in the creek. So as I have lived there, like I said, full-time for over 28 years, and I have seen lots of changes, and the water is coming up. It is encroaching on the banks. We never used to have any kind of flooding on our property at all, and now we do, due to what, climate change and the way the marsh migration is going. So I believe that the OCRM buffer zone is close enough to the creek that in time, I don't know if it's going to be next month or the following month, or even a year from now, but it will encroach on that farm road.
Okay, so the Bolts as property owners are facing the same adverse conditions as any other property owner with climate change and rising tides, right?
Right.
But yet as I sit here and I read all these letters and all these comments, it just seems like there's a tremendous animosity and hostility for the Bolts, and y'all just seem to be picking at every little picayune objection you can think of to slow them down. And I don't see any evidence of anybody reaching out to the Bolts and trying to forge some sort of neighborly relationship with them.
But you know, if you think about it, okay, we've been on the creek for a long time. They have just come on the creek. We do not have a road that runs on the side of the creek. We do not have any sand shell roads that run on the side of the creek. And we are not having any kind of commercial existence there on an Ag 15 property that is going to use a road that was really maintained for hunting or just a small agricultural road. I don't care if they have that road if they just don't go through the OCRM. I don't want it there.
But the road's been there for 20 years, so it was
Yes,
there.
but it hasn't been ridden on with big trucks and I guess vacationers and also supplies. So I think that the road was not intended to be that kind of road. They can have that road, but just take the OCRM buffer area and move it over.
Okay.
That's my thing. And I think you need to think about how are they going to protect the road in the future for not causing problems, because once you lose the viability of the creek and the wildlife, you will not get it back.
Thank you, ma'am.
You're welcome. Thank you for hearing me.
One moment, please. Do we have anyone else that'd like to speak with Ms. Gunter? No other hands. Thank you so very much for coming tonight and speaking to this board. Ms. Workin, who would be the next person available to speak?
Fred Gunter?
Oh, Jenny, Fred,
yeah.
it was either one. Fran is
Okay.
fine for both.
All right, is Tatiana Thomas there?
Yes, I'm here. Hello, can you hear me?
Yes. Okay, please raise your right hand. I will say the oath, and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. And if you can just state your name and your full name and your address for the record, and then tell the board your thoughts on this case.
Sure. My name is Tatiana Thomas, and we have property on 6543 South Mount Road. It's on the Fickling Creek. We have a dog there. And I just want to say, first, I want to address the hostility issue. I personally wrote letters, and I have been, the letters that have been written to the board were shared with me by neighbors, and I did not see any hostility. It can be perceived that we are opposing proposed variance as hostility, but we are just simply there to protect Wadmalaw Island, our Fickling Creek, our livelihood of the flora and fauna on the creek, and we are looking into the future. And we are just protecting our Wadmalaw AG-15 zoned creek. Now, the road that is existing, it was a farm road. It was like a musket that was, when Constitution was written, right to bear firearms, there were muskets at that time, not the Uzis and semi-automatic weapons. So that road is a farming road, just for access to hunting grounds and to the farm. It was not meant to be used for commercial use, everyday use, multiple times, encroaching on OCRM buffer, protected buffer. That's what we are against. We are trying to protect the Wadmalaw Island and AG-15 land. And the business operation and hotel operation is not supposed to be there to begin with. And this is not a hostility, this is a statement of fact. So yes, I am in a vehement opposition to that proposed variance.
Thank you, Ms. Thomas. Do we have any board members that have a question for Ms. Thomas? I see none. Thank you so very much, Ms. Thomas, for speaking with this board tonight.
Thank you.
Ms. Working, thank you. Who do we have next?
Is Dr. Arthur Packold there?
Yes, I'm here.
Okay. If you can please raise your right hand, I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. And please state your name and address for the record and tell the board your thoughts on this case.
Yes, my name is Arthur Packold. We live on Fickling Creek. The address is 6543 South Mount. It's the opposite side of the creek where the Bolt tree farms are. I have been there for 25 years. So I can speak with an autopsy what I have observed. Number one, the issue of hostilities has not been created by us. The origin of the hostilities, if one could name it that way, is because there has been so much untruthfulness, so much wrong statements by the applicants. In fact, on the last meeting, and by the way, I wasn't able to be present because I was stranded in Europe because of the COVID. I was there 5 months, 4 months overdue. So I couldn't come on time for the meeting, just simply impossible. So in the last meeting, I saw it on the recording, the applicants have been named in a contempt of court. Now, the attention is requested to the last meeting. So I am in a strong opposition to the proposed road. Number one, the road was not in existence as it is today 20 years ago. The road was not existing as it is today. And I said that under oath, and we all witnessed that the road was not there in 15 years ago. And I clearly say that loud and clear. The creek is eroding toward the road. Now, Billy Storen, who owned a hell of a lot of property on that side, they had picnics every year that I've been there many times. Since then, his property has moved about 10 meters, 10 meters. Well, I would say maybe about 12 yards, more understandable in this country. So he has lost 2 huge oaks on that side. The property to the right, where I look at the Fickling Creek, has also lost a bunch of oaks. So the creek is moving. It's a viable structure. It is only a matter of time when that creek is gonna move into the proposed road. And then we're gonna have requests for retention wall, refurbishing and all that. But that road was not as it is today, not 15, probably not even 10 years ago. And as I said, I'm on the oath. So that's all I have to say, that I'm strongly in opposition, backed by the above stated facts.
Thank you so very much for your testimony. Do we have anyone that would like to ask Mr. Packle? I'm sorry, how do you pronounce your name again, sir?
Packle, P-A-C-U-L-T, Packle.
Packle, I apologize, thank you.
No,
Mr. Goldstein has a question for you.
Hey, can Dr. Packle see me?
Yes, I can see you, Mr. Goldstein, yes, very clearly.
Does that look familiar?
I do, you do. But that may be irrelevant to the case, so I'm very careful.
You know who put,
a little humor.
You know who put that there?
Yeah. So please go ahead. I'm listening.
In the letters of opposition, there's a constant reference to the area being commercialized. I think you just used the term commercialized. Are you aware that Charleston County Council has declared short-term rentals under the proper permit, of course, to not be a commercial use?
Yes, I am very familiar with that. And I have been to the meeting on the Charleston County several months ago when they withdrew their application for rezoning. As you will know, that this entire application was on a wrong premise. And that's why they backed off. They wouldn't get it anyway, but they did back off because it was, there was a bunch of lies.
Right, I understand.
That is why they are in contempt of court.
Well,
so that's the origin of our hostilities, if I might finish up.
Sure. There seems to be a high degree of hostility. There's no doubt about it. And a lot of it seems to stem from the misapprehension that short-term rentals are commercial when county council has declared that they are not. But the other thing is, I wanted to ask you about this as a highly trained scientist. That area is zoned Ag 15. So if that were a working farm, either for livestock or commercial planting, you agree that that would be a larger degradation of Fickling Creek than the current use. You would agree with that, correct?
Well, as long as it is far away from the Fickling Creek. I mean, we have a tree farm. This is industrial place, and we do not have any objection to their existence.
Yeah. Okay.
But they are peaceful, I would say, neighbors.
Well, is there
no hostilities, no unjust hostilities there?
All right. Well, is there anything that I can do sitting here right now, volunteering my time in the future to lessen the hostility?
Well, hopefully overrule the zoning decision.
Okay.
Mr. Goldstein, thank you very much.
It's good to, I didn't get to see you, but it's good to hear from you, Dr. Pakal.
You're very kind. Thank you.
Does anyone else have a question of Dr. Pakal? I see none. Thank you, sir. Oh, wait, I take that back. Mr. Nelson.
Just one question. Dr. Pakal, I appreciate your time as well.
Yes.
You indicated that 20 years ago, the road was not present on the property.
Well, please make it very, I want to make it very clear. The road, as it is today, was absolutely not present there 20 years ago, without a question. Someone, I don't know, was adjusters or who, but somebody refurbished that road. We can call it rejuvenated, whatever. But that road, as it is today, was not there, not 20, but 15 years, possibly even 10 years ago. So this road has been renourished in the existence to the current existence as long as the balls are there. So I'm very sure to tell you that this was done illegally.
Okay, just so you know, the applicant did provide a photo from 2001, and I think it's also up on Charleston County's website. It does show the road there.
No, there is a road. Please don't understand me wrong. There is a road. It was a hunting road. It was not a road for any commercial use. This is not the road that you could have drive a car back and forth or order pizza from a Domino's Pizza. That road would not be able to be used for that purpose.
Okay, I understand.
There was a track. There was a tract. You would say that a goat track, like we call in Europe, when you take a goat up to the pasture. But it was not a road.
Okay, I understand now. Thank you.
Yes, sir.
Does anyone else have a question? I see none. Thank you so very much again, sir, for your time tonight.
Thank you.
Ms. Workin, who do we have next?
So the next three speakers on the list look like they're signed in, but I can see if they're there. They are Sally Muir, Melinda Kelley, and Victoria Fowler. Are any of those three in the building, or are they on individually?
They're individual. They're not on here with us.
Okay. All right. So I will take them in that order. And then after that is Kelly and Pam Skinner. And that's the final, that's the 11th one. So I'll mute Pam, and we will promote Sally. So. Sally, can you hear us? Sally?
Yes, I'm here.
Okay, great. If you can please raise your right hand, I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. If you can please state your full name for the record and your address, and then provide comments to the board.
Sure. Thank you very much. Sally Bland Muir, 6555 Southmont Road, Wadmalaw Island, South Carolina. I want to thank you all for the opportunity to hear my voice on this issue. I want to also and I know I'm under oath, say that that road was not here 13 years ago when we moved to Wadmalaw. There was a rough, very rough, overgrown hunting path, no more than that. The creek, and you've seen plenty of photographs because many of us sent them, of the bank in front of the Bolt property is eroding. It's being undercut by the current. You can actually see where the high tide has come, is rising, and you can see, although it's deceiving, how very close what is now a road, was not there before, not in that location, is very close to the road, and it will collapse. It's a matter of time. We don't know when, but the tides are rising. Everybody knows it. Everybody agrees. For me, the essence of this is I have to pause and reflect on why the applicant would want to keep a road where it is when it's obviously going to collapse. They're not in a position, OCR regulations do not allow them to put in a bulkhead, which would cause further destruction along that part of the thing. It's very simple to move it back out of the OCRM and solve this problem instead of just keeping on one violation, one variance request after another. The creek is rising. You've heard it from everyone who's lived there. I don't know who the last person was to move on, but I think people have been there at least 10 years and almost 30 and care about the creek. It's really simple. OCRM has critical lines on purpose and for a reason. No one, particularly in these circumstances, should anyone abuse that. Charleston County has raised its building footprint from 1.5 to 3 to now 2 to 3 feet. Didn't do that by accident. It did that based on the Dutch dialogues, NOAA, and its own tide rising conferences. It's very elementary to me. I don't know why it's just gotten drawn out like this. Just move the road, that little piece. I was behind trucks on the Maybank Highway for days, back and forth, bringing that road fill in. I didn't know where it was going. I did follow it to the driveway. I had no idea that they would be encroaching or that anybody else would be encroaching because we just don't do that out on Wadmalaw, particularly Fickling Creek. Just move the little piece back. Nobody's taking away the road. They just want it out of the OCRM critical line for all of us, including the Bolts. Thank you very much. Please reconsider.
Thank you so very much. Do we have anybody to ask Ms. Sally a question? Ms. Murr, excuse me. Anyone? Thank you so very much for your testimony tonight. Ms. Workin, who do we have next?
Next is Melinda Kelley. Okay, Melinda, can you hear us? Melinda? I gotta ask her to unmute. Melinda, can you hear us?
I'm here, Jen.
Okay, great.
Yes, I can hear you.
Okay, great. Please raise your right hand. I will say the oath, and you will say, I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Okay, thank you. And if you can just say
Can you hear me?
Yes, your full
Uh-huh.
name and address for the record, and then provide comments to the board.
My name's Melinda Kelley. I live at 2124 Allendale Plantation Road on Wadmalaw with my husband, Joe Kelley. I'm speaking on behalf of the Wadmalaw Island Land Planning Committee and also personally because we feel strongly about this as well. I do believe that a variance is needed because of the violations of 9.7.1, the wetland buffer itself. There have been some comments made about the 9.7.2, the fact that the road is permeable. And yes, the ordinance says that you can't have impervious. And so it's, thank goodness, at least it's pervious. But it's a question of distinguishing the type of road and where it is. It's located in the buffer, and it's in violation of that ordinance. And just as Ms. Muir said, OCRM has critical lines for a reason. Charleston County has this wonderful wetlands buffer ordinance, and I think it's adopted for a great reason. And so it's just right in the middle of it. And also, like Ms. Muir said, it's a small piece. It's not a huge inconvenience to move this little small piece that was outlined in yellow that they knew about when they had the site plan approved. So I do feel pretty strongly that a variance is needed. The other thing is that 9.7.1 of the wetlands buffer says that it specifically says that driveways have to have the buffer between the water and the driveway. So I feel like it's real strong as far as the violation, because they don't have that buffer between the driveway and the water. And that's stated, just specifically in the ordinance that you have before you. The other thing is that I feel like this just doesn't meet the variance elements, the hardship test. They use the road as the exceptional condition. And I've honestly I don't know if I've ever heard of using a violation as the exception. I feel like it's not in the right place. And so I don't think it should be looked at as the exceptional condition. And I also feel that in the next section of the hardship test, which is B2, the exceptional condition is B1. B2 is that there are plenty of properties around Wadmalaw and throughout the county that are on water. And so this definitely should meet the requirements. It's not that it has some magic kind of characteristic. This is similar to any property that's on the water, and the OCRM ordinance would have to apply to anybody. The next section that I think wasn't met is that 3.10.6B3, which says that that there would be an unreasonable restriction to the use of the land. I agree that it's just a small little area, and to have it moved doesn't seem to me that it would restrict the use of the property. The lot itself over there is a large tract, and so I feel like that point is not met at the hardship test. And then I want to jump down to well, I'll go ahead with B4. It's already been mentioned, so I won't go into it too much, but the environmental and ecological impacts, I think, are detrimental, and it would be a problem. Number B5, when Mr. Nelson asked about the expansion, and Dr. Bacolt and Ms. Muir both said that the road had not been there, excuse me, it had been just a path. One of the requirements of the hardship test is that you cannot expand. Now, I don't know if this would be considered a non-conforming use or not, probably illegal non-conforming use, because it may or may not have been used in this way, but everyone has testified, or everyone who has testified has said that it wasn't the same, and now it's enlarged. So I think that's something to bring up. And then B6 says
Kelly,
that it
Ms.
wasn't
Kelly, I hate to
known.
interrupt you.
Yes.
Ms. Kelley, your 2 minutes are up. I'm sorry.
Yes.
Unless someone's willing to yield some of their time.
Oh, sorry.
Your 2 minutes. All right, that's quite okay. Does anyone have any questions for Ms. Kelley?
Sorry.
No, that's quite okay, Ms. Kelley. Mr. Boykins.
Hello, Ms. Kelley. How are you?
Fine. How are you?
Doing fine, doing fine. I wanted to say, you brought my attention to another part of the Zelders that I guess didn't realize was applicable, and you make a very good point. In reading 9.7.1, you're exactly right that the intent of that article was to provide a buffer between a driveway area, and a road would certainly constitute that. I voted for the variance initially because I didn't believe they even needed to have a variance because of, like you said, what was prohibited under the prohibited activities. But your arguments make sense to me that in plain reading, the prevention of roadways within that critical buffer was something that was intended in this Zelder to begin with. And so I will say that I'm moved by your comments, and I've changed my mind on this from where I was before. So thank you for that.
Thank you.
Thank you, Mr. Boykin. Mr.
much.
Goldstein has a question.
I do. Ms. Kelley, the argument that you rely on from Ms. Muir that it's only a small piece of the road that infringes on the OCRM, you would agree that's a two-edged sword, correct? If it's only a small piece, then the request for a variance is a request for a very small variance, right?
No, I disagree, Mr. Goldstein. I mean, a variance is a variance in my mind, and it is small compared to this 34-acre piece of property, but it is about 150 feet. So it's not, I don't mean small like a foot or two. It's significant. And so I would have to explain it that way, that it's still significant.
Okay, so it's significant. It's not small as you and everybody who preceded you said. All right. Well, let me ask you this. How many people on Wadmalaw Island have docks? A lot?
No idea, but we were just out on the water yesterday and noticed, I don't know, over a dozen in our little creek.
All right. And so in order to get to the dock, you got to cross over the OCRM critical line. Isn't that right?
No, not necessarily the way they're doing it. The way they're doing it is using cars and trucks and people who come and supply goods, and all the visitors and guests and party goers. People that go out on their dock usually walk in the backyard. So that's not a driving situation. I mean, we would never consider we live on the water, but we would never consider having a road going through our property down by the marsh. It's just not very responsible to do that. So I've never noticed little roads unless it's a marina.
Do people operate powered boats up Ficklin Creek?
I don't know Ficklin Creek, to be honest. I just, so I don't know, but you mentioned that it was not a commercial use. And I hope I can jump in real quickly and say that they have a business license. It's not for short-term rental, but their use is for month-to-month rentals. So anyone on the creeks in Wadmalaw, it's not short-term rental that they have, it's the month-to-month. And they had to get a business license. And so it is commercial to that extent, it's a business. And so most of the docks that you've asked about are just homeowner docks. And those, I've never seen a road that connects dock to dock or anything like that.
Well,
Everybody just has a backyard and you go out, and if you have a dock, you walk down there.
Well, in your opinion, what would have the most impact on Fickling Creek? The Bolts Road or 7 or 8 docks with power boats on the end of them? Which do you think would have a greater impact, in your opinion?
Well, you know, that's kind of that's a question that's got a hard answer, Mr. Goldstein, because boats, they may have gotten a dock permit years ago, and this is now this situation. And I just feel like the impact certainly is great from boats. I mean, I agree with you, but we don't know the background of who has boats. I don't know how many docks are on Fickling Creek. I do know that this particular situation can cause problems. I mean, this is a little road that shouldn't be within the OCRM buffer. And to me, it's, I hate to, I know that I don't mean to be rude and not answer, but I just don't know the answer to the history of the docks on Fickling Creek. I feel like
everything, you know, we do as human beings has a potential
serious
adverse
situation.
consequence.
Sure. That's true. But in this situation, they've got a lot of activity, lights, who knows what kind of fluid leaks, runoff. I mean, that's why there is this particular buffer. So everyone with a dock may not have to worry about the buffer. They may not have a road, or they may perfectly comply with the ordinance. This is a violation of the ordinance.
All right, so you agree that as long as the road is made out of sand or sand shell, that it does not require a variance. However, you contend that if it's a driveway, it must maintain the minimum buffer. That's your argument, correct?
No. Actually, because it is sand shell or gravel or whatever it is, to me, that's immaterial. That's kind of a red herring. It's the location that matters, not what it's made of. And thank goodness it is pervious. But so see what I'm saying? That the fact that it is made of that material doesn't matter. It's the fact that it is in the wrong place. And that's why the variance is needed.
Well,
it's
now
a distinguishing factor.
Then we have to struggle with statutory construction, because we got one ordinance that says as long as it's pervious, they don't need a variance. And then we've got your reliance on 971 that requires driveways to have buffers, right? So we got to weigh those two ordinances.
Well, the 97, the whole ordinance is the wetland buffer ordinance, establishing the width of what can and cannot go. The fact that their claim is that the buffer is pervious and that impervious roadways would not be required, that's completely consistent with what I'm saying. Yes, they should have a pervious road, but not in that location. So I think that they're squared in the fact that if it's a permeable road, it would not be allowed. It'd be prohibited, because that particular section says they're prohibited. But what I'm saying is that the overall section of the wetlands buffer ordinance does not allow roads within the OCRM buffer, pervious or impervious. And so that's my argument.
Okay.
Thank you, Ms. Kelley. Do we have anyone else that has a question of Ms. Kelley?
Thank you.
Thank you for your time, Ms. Kelley. Ms. Workin, our last person to come speak. Was that the last one, Ms. Workin? No, Ms. Fowler.
Can you hear me? Jenny, I believe you're on mute. Sorry.
Okay, sorry about Uh, Please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. And then just state your name and address for the record and your facts to the board.
Victoria Fowler, 2539 Grace Chapel Road, Rockville, South Carolina. Y'all ready for me?
Yeah, go ahead, Ms. Fowler. Please tell this board why you're here tonight.
All righty. Thank you so much for allowing me the opportunity to speak. And also thank you, Mr. Goldstein, and the other board members who did read my letter. I think something needs to be brought up again and pointed out was at the last board meeting, this board certified contempt of court based on testimony given at the tree encroachment hearing, which stated that the units were going to be used as a personal retreat for friends and family. In the letter of intent for the site plan application review, that same purpose was stated, that this was not to be for rent and that these units were going to be for personal use. By granting this variance, it's basically enabling a commercial operation, and approving a site plan or approving a variance request based off a personal use driveway, I feel is much different than approving a variance request for a commercial road that allows for guest traffic, vendor traffic, delivery traffic, and the like. But that aside, I feel that this variance request, if they felt like they didn't need it, they should have approached the BZA in 2017, appealing the planning director's decision. That way, the planning director could have established why a variance was needed. They could have provided their case, and the public could have also provided comment, and this could be in a natural setting and with no improvements done to it whatsoever, and then the board could have a fair opportunity to weigh their decision then. This wasn't the case. This is now 2020, and this is being brought up. And while many of the speakers tonight have testified that it was improved, and their counsel has said he did not believe it was improved, the fact of the matter is we don't know truly what it was like in 2017 because we aren't hearing it in 2017. So their argument for a variance request right now and their hardship is based on the fact that they have done improvements to this road. And if this variance request is approved, I request that it be based off a 2017 decision, not a 2020 improvement decision, but also if it is approved, could future use conditions to really protect the OCRM be put in place. And that's all I have to say. Thank you.
Thank you, Ms. Fowler. Do we have anyone does anyone have any questions for Ms. Fowler at this time? Okay, I don't see any hands. Ms. Fowler, thank you so very much for your testimony tonight.
Thank you.
Ms. Working, we have another person that would like to speak.
Yes. Okay. Ms. Skinner or Kelly or Pam first, whoever wants to go first. Those are the last two speakers. Mr. Skinner?
Yeah, Jenny, can you hear me? This is Kelly.
Yes. You want to go ahead and speak first?
Sure thing.
Okay.
Well, okay, yeah. I'll speak first and she'll speak after me.
Okay. Please raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. And then state your name and address for the record.
I'm Kelly Skinner at 1437 Fairview Plantation Road on Wadmalaw.
Mr. Skinner, please tell us why you're here tonight.
All right, well, so first off, I want to thank you guys for hearing all the voices that were unable to speak in July. And that was one of the objectives that we wanted to make sure that everybody's voices got heard, and we do very much appreciate you guys doing that. I would ask not to confuse hostility with frustration. You know, this is not about any kind of personal feelings or hostility. This is all about land use, proper and improper. So by the Zeldar definition of a hotel, this is a hotel, not STR. And as Ms. Kelley pointed out, their business license with regards to long-term leases reflects that. It is not a proper land use on Act 15 property. And just as you all had struggled in the July session with the idea that sand can be considered pavement, we struggle to see how this is not a hoteling operation. So we are all obviously very passionate about protecting our home as the comprehensive plan envisions Wadmalaw Island. But you're asking the community to bridge with the applicants and suggesting oyster renourishments, et cetera. You're asking us to essentially legitimize a hotel that we absolutely vehemently oppose. So this is a hoteling operation business. We are simply trying to navigate the Zeldar and the comprehensive plan the best we can to protect our homes and island. And we just ask for help in doing so. So thank you very much for your time and hearing us out.
Thank you, Mr. Skinner. Please hold tight. Do we have any questions of Mr. Skinner? Does anyone on this board have any questions for Mr. Skinner? Okay, I don't see any. Thank you so very much again for your time, sir. Lastly, I think we have Ms. Skinner.
Yes, that's correct. Ms. Skinner, if you can please raise your right hand, I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth I do.
I do.
And state your full name and address for the record.
Okay, it's Pam Skinner, Fairview Plantation Road, Wadmalaw Island, South Carolina. And I think my husband properly addressed the hostility. That was in my notes. I wanted to address that, but I think that was addressed. And I also wanted to mention that, and not to be disrespectful, Mr. Goldstein, but I just wanted to remind y'all that it was Mr. Gaskins who said that it was a small bit of road within the critical line. It wasn't us necessarily, because we do consider 150 approximate linear feet to be an issue. And as the pictures, we spent a lot of time identifying many areas in the ordinance, within the state and Zeldar ordinance regarding the critical line buffer. Marsh migration is a huge issue. In my letter, I showed you one of the properties that does have a dock. It has a oysterman's shed on it that was built in the 1900s. That was where the oyster reef was put in that has failed. And we keep hearing that it's not a commercial because for some reason we are very clear that short-term rentals are no longer applied there, that Mr. Evans revoked that permit for violations in November of 2019. So we're very clear that short-term rentals, but we are also very clear that there are monthly rentals in there, and the applicants advertise HelloFresh and UPS and FedEx, they all come in. Victoria Fowler provided you with a video of a guest who was terrified driving down the dirt road. So I can only imagine when they were going to the tree house that's that's about 3 feet off of the marsh, that they would be quite concerned. And we're quite concerned that their car would end up in the marsh at night. And as far as someone else brought up the 2001 imagery, which I also brought that up, because I was looking, it was a farm road, and I saw that in 2001, there was a farm road there. But I also realized that a critical line survey is required for every 5 years. I don't know that there was a new survey done for this property. And one final comment I had on the 9.72 for prohibited activities, where everyone within the BZA honed in on Part D, that it was not a paved or impervious surface, but there was removal, excavation, or disturbance of the soil. Because we have pictures within the dwelling group when they were doing their site survey of big tractors in there that brought in that shell sand that you're talking about. So there was not minimal disturbance. And in my letter, the letter my husband and I sent, we showed you what the adjacent property looks like. That's not been disturbed. There is a huge difference between the two properties. So that was what I also wanted to point out with my comments. And there is not hostility, but a lot of us don't like, fool me once, shame on you, fool me twice, shame on me. I think that's where a lot of us are right now with this situation. And I'm sorry y'all have had to hear it 3 times, but it's something that we're here to protect what we love, and that's the island and our standards for Ag 15. Thank you.
Thank you so very much, Ms. Skinner, for your passionate testimony. Do we have anyone that has a question for Mr. Goldstein?
Yes, you gave your address as Fairview Plantation, is that correct?
Road, right. I do not live on the creek.
Okay. You also have a residence on Seabrook Island, is that correct?
As of October 12th, I will not. It's being sold.
Okay,
But I'm glad to see you did some research.
What did you use that property for?
It was a short-term rental, which is allowed by the town of Seabrook Island.
Okay.
And I lived in it. I have lived and owned property on Seabrook Island since 1982, by the way. And because of the way things have happened, I have made the decision to sell my property because that's no longer the land I love out there. That's why I'm fighting right now for the putt-putt course. I'm opposed to a putt-putt course out there on Betsy Carrison because I have seen the changes that have happened on Johns Island over 40 years, and I will continue to oppose those type of things to keep Wadmalaw saved. And I am also honoring the work of people like Lewis Hay and other people who came up with the Wadmalaw plan. And I don't know if any of y'all have read and are familiar with the Wadmalaw plan, but I think if you go back and review this, you will also see that in 1988, Lewis Hay, Mary Frances Brown, and Eddie Chisholm, 18 other islanders got together and developed this. So when you think we're passionate, my husband had it right. We're frustrated. We're not hostile. We love this island and we will protect it. And I don't really understand the fact that why I own property on Seabrook has anything to do with this. I'm sorry. I'm struggling.
Thank you, Ms. Skinner. Thank you so very much. Do we have anyone else that has a question of Ms. Skinner? I don't know. Okay, thank you so very much, Ms. Skinner. Ms. Working, was Ms. Skinner the last one?
Yes, sir. And I was going to get on Mr. Gaskins for his rebuttal, if that's okay.
Yes.
Okay.
Yes, please.
Okay. Okay. Mr. Gaskins, can you hear us?
I can hear you. Can you hear me?
Yes. Okay, your rebuttal time starts now.
Okay, I will try to be brief. First, as to the issue of whether the road is existing or not, I think the 2001 aerial speaks for itself. Clearly, there is a road. As to the improvements that were made to the road, if you look at that, you can see that the northern portion of the property does not connect to Maybank Road. The additional gravel and sand shell was used for that. Secondly, there were a lot of concerns raised about the road being used for commercial uses. This is not a commercial use, as Mr. Goldstein stated. It is also no longer being used for short-term rentals. It is being used for long-term rentals, and the amount of use is very minor and has been grossly exaggerated by the opponents. Next to last, I want to talk about the perceived inconsistency between sections 9.7.1a and sections 9.7.2 that Mr. Boykins brought up. And as Mr. Goldstein stated, this brings up questions of statutory construction. And under the legal doctrine of lex specialis, the specific governs the general. If you look at 9.7.1a, that deals with the intent of these sections. It does not lay out the specific uses allowed in the buffer or the prohibitions. That is set forth specifically in 9.7.2. So if there is any inconsistency between those, 9.7.2 governs. And under 9.7.2, the use of a pervious road is not a prohibited activity. And last, I would just appeal to your common sense. We have been on this call or this meeting for over an hour talking about moving an existing road approximately 20-25 feet in a way that is going to destroy vegetation. To me, that doesn't make any sense. And so I would appeal to your common sense and ask that you stick with your original decision and grant the variance. Thank you.
Thank you so very much, sir, for your reconsideration, rebuttal, excuse me. Does anyone, Mr. Boykins, you have a question of the applicant?
I do. Mr. Gaskins?
Yes, Mr. Boykins.
I wanted to get your thoughts on this. If you are correct, and I don't have any reason to believe you're not, that 9.7.2 would govern over 9.7.1 when there's either a conflict or ambiguity. My question to you, though, is clearly the intent was not to have roads within the critical buffer. I mean, the whole purpose and the intent of this ordinance was to have this 35-foot buffer. Section D under 9.7.2 says it may not be any paved or other impervious surfaces. It doesn't mention roads or driveways in that language. You could have a patio, you could have walkways, you could have other things that this may have been intended to cover. It also says it does not prohibit permitted crossings, which would be decks and things that would get you to your dock when you had a permit for that. But what I'm getting at, though, what's kind of counterintuitive is if a road were to be allowed within the critical line buffer, Section A under 9.7.2 would make the maintenance of the road impossible. Because as we all know, many of us that live on dirt roads and have dirt driveways, you've got to grade it with a tractor and you've got to perform maintenance on it. And A would effectively prohibit any maintenance on that road as it deteriorated from vehicle traffic, potholes and everything else, and the manipulation of soil and materials, because it's very specific. It says that no removal, excavation, or disturbance of soil, and it gives you only one exception. And that's for minimal disturbance associated with planting shrubs and trees for landscaping, which is not maintenance of a driveway or a roadway. So again, I think that's more evidence of the intent that roadways were not something that they wanted to have allowed within the critical line buffer. And Section A effectively prohibits the maintenance of any such roadways. So what are your thoughts on that?
So I don't necessarily agree that the maintenance of the road would require the removal, excavation, or disturbance of the soil. I will take your point that it may not allow the creation of it if it would disturb the soil. But I think you also have to look at, in these particular circumstances, when this ordinance was adopted and whether it was intended to require the relocation of a road that has existed for many years. And I think under these particular circumstances, where there's been an existing road that requires minimal maintenance, not additional disturbance of the soil, that this is a permitted use, and that if the county council intended to prohibit all driveways of that sort, they certainly could have done that in 9.7.2 expressly. And because they haven't, I believe that there is no violation with respect to this existing driveway.
Well, I guess it's two things. One, I think that the applicants would have to have a variance to have the road where it is now. And it would be up to the board to grant that variance or deny it if we do reconsider our past decision. But again, it's two issues. I think the law is, to me, is clear enough that in reading it in totality, it doesn't seem to be conducive of putting roadways within the critical line buffer, because number one, you'd have to remove trees and shrubs that are, again, is another prohibited activity to construct a road. You certainly would have to disturb soil. And again, I've got a tractor and a blade, and I have to take care of my road, and most of my neighbors do out here on Johns Island. And, every time it rains, you get potholes, and you're gonna have to do some work on it. And again, the language of the prohibited activities are not conducive to the maintenance of a roadway. And I think it further supports that roadways were never intended to be allowed in the critical line buffer. That's my reading interpretation, and we'll have to see what the board does. But I did hear your arguments, and I think Ms. Kelley made some good points as well. So that's kind of where I stand, but I thank you for your time.
Thank you.
Very good. Mr. Goldstein, the chair recognizes you, sir.
Thank you, Mr. Chairman. Mr. Gaskins, I got two questions. One, do you know when the buffer ordinance was enacted? My book is on the other side of the room. I didn't want to leave my desk and go get it. Do you know when it was enacted?
So all I can go on is what's online based on the research that I've done. And it says that 9.7.2 was effective on 11/20/2001, and that 9.7.1 was effective on 7/24/2018 as amended. So I don't know if there was a previous version or how that version read. So I'm sorry, I don't have that specific information for you.
All right. Well, do you have evidence one way or another as to whether the road did or did not exist? And I know it was a hunting road, did or did not exist prior to the adoption of the buffer ordinance?
It appears, so this is a 2001 aerial image, and given the condition of the road, I think it's very reasonable to assume that this road, which appears to be more than just a hunting road, this looks to be used for agricultural purposes. If you look at the entire parcel, existed as of the date that 9.7.2 was adopted, according to the code, the ZLDR online.
Okay. You said your clients are currently using the property for rentals not less than 30 days. Is that what you said?
I believe so, 29 or 30 days, whatever the definition of short-term rentals is, but they're doing long-term rentals.
If they're renting the property for 30 days or more, is that governed by the short-term rental ordinance or not?
It is not.
Okay. Last question. I want to end up with Ms. Fowler's comment that she says, if we're inclined to grant the variance or affirm our previous decision, she says, please give some consideration to, and this is a direct quote from Ms. Fowler, future protection of OCRM uses and restrictions. Can you suggest a middle ground that might move your clients and the objecting neighbors toward a middle ground that would allow the road to be maintained, but at the same time reinforce their mindfulness of the delicate nature of the OCRM buffer? In other words, could we put a condition on it that would give some assurances to us and to the neighbors and to OCRM that there would be no further improvement? And I know you already answered this question once. You said, well, you can't do that anyway. The ordinance prohibits it. But can you give us some suggestion for language that might help turn the temperature down a little bit?
That's a good question, and you're putting me on the spot, and I likely could come up with something. I can't think of anything here today, but what I will say is, although we certainly understand the neighbors are not happy about the short-term, the usage of short-term rentals, but
well, it sounds like you've cured that.
Well, we have out of necessity, but regardless of whether it was used for short-term rentals or not, the property has always been intended as a rural natural retreat. It is not a hoteling operation. It is something that they market or marketed as some place to go and get away from the city or from urban areas. And the intent has always been to respect the natural environment on the property, and they do so. And so, I think they can feel assured that there's not going to be some degradation of the environment based on their usage. That is just not consistent with what they have used the property for.
Well, would you have an objection to a condition that allowed county planning staff to inspect periodically to examine the sand shell road to determine if it was degrading Ficklen Creek or showing signs of collapse?
Again, I'm reluctant to agree to anything without speaking to my clients beforehand, Shirley. I think you understand that. I'm not saying I would be opposed to it, but or they would be opposed to it. I just don't have enough information to commit to that. I will say that, you know, since at least October of last year, we have tried to work cooperatively with the county staff, and which is the whole reason that we're here today. Is we recognize that there were some issues in the past, and we're trying to rectify that. And my clients have tried to work with the neighbors, and so we're committed to improving the relationship not only with the county but with the neighbors. And so I think we'd be open to it. I just can't commit to it without speaking to them directly.
Okay, thank you, sir.
Thank you, Mr. Gaskins. Thank you, Mr. Goldstein.
Thank you.
Anybody else? We need to bring this to a close. Ms. Working, anything else? Anyone else? That's it?
No, sir.
All right. At this time, board, you've heard testimony from both sides and a rebuttal. At this time, I'd like to ask for a motion to either support.
Can I ask a question of council, please?
Please, Mr. Goldstein.
Mr. UG, would a motion be to affirm or disaffirm our previous decision, or would a motion be to grant or not grant the variance while requiring stating of all the statutory factors?
Calvin, you're on mute.
Sorry, it would be to affirm or overturn your prior ruling.
Okay, all right. Well, I'll make a motion then. Did anybody?
Go ahead, Mr. Goldstein.
Well, I didn't
go
want
ahead.
to jump in. If somebody wants to go first, I'll stand down. Is there anybody else?
Does anybody want to make? You had the floor, it seems, Mr. Goldstein.
All right, well then, I didn't want to cut anybody off. I'm going to make a motion that we affirm our previous decision for that, having carefully listened to the testimony and reviewed the written materials, which were thorough and exhaustive. I can find no error in the board's conclusion in granting the previous variance. I am prepared to make an additional condition if that is allowed. Mr. UG will have to tell me if that's allowed or not. If it's not, then I'll withdraw it. But my motion is to affirm our previous decision with the additional condition that the planning department retains jurisdiction to inspect periodically the shell road, sand shell road, to evaluate it for signs of degradation or collapse.
Mr. Goldstein?
Yes, sir.
I am not sure they have that authority. I believe.
Okay, well then I withdraw that condition. My motion is to affirm, after carefully considering the written comments and the testimony of all persons, that we affirm our previous decision.
Okay, we need a second. We have a motion on the floor. We need a second.
Second.
We have a second. Now, Ms. Working, if you would please call the roll.
Okay, and that second was Mr. McConnell, correct?
Yes, Mr. McConnell made the second.
Okay,
Sorry.
got that. All right, so the
So do you-
motion was to affirm the previous decision made July 20th. The motion was made by Tommy and seconded by Mr. McConnell. Mr. Ray? How do you
Aye.
vote? Aye, okay.
Aye.
Ms. Lechner?
Nay.
Okay. Allison, Ms. Allison?
No.
Mr. Boykin?
No.
Mr. Freeman? Okay.
No.
Mr. Goldstein?
Yes, aye.
Mr. McConnell?
Yes. Aye.
Okay. And Mr. Nelson? Mr. Nelson?
Aye.
How do you vote? Aye?
Yes.
Okay. So that is 4-4.
I guess we need a parliamentarian then.
Yes, please.
Okay. So at this time, we don't have a majority, nor do we have 2/3 vote. I guess we have to, I'm unsure what we have to do. Mr. Hughie, at this point, can you tell us what we would need to do?
You can, well, can you hear me?
Yes, sir, I can hear you.
Oh, he's muted.
Mr. Hughie, you still have your mute?
I'm sorry. Jenny, what was the roll?
It's 4-4, and my understanding is you need 2/3, so you need 6 members for the motion to pass. 6 of the 8.
Right, so the motion does not pass.
Okay. And do we need another motion?
Yes. Is there anyone else who wants to submit a motion to the board?
A question. I'd be happy to make the motion the other direction, but I think the vote would come out exactly the same. I don't know if that would just be a moot point to do that. So I think we're stuck.
Do you all want to have any further discussion?
Well, I have a question of council.
Mr. Goldstein?
Thank you. If it's going to be tied 4-4, does it require a 2/3 vote on a motion for reconsideration? I thought that was a simple majority, but regardless, we're still tied either way. Would it be appropriate to postpone the vote until there are 9 members so that there would be a, well, I guess if it's 2/3 vote, that's not going to matter, is it?
I would need to check the rules. Jenny, do you know offhand if it's a simple majority?
I don't know. I mean, I thought that we were rehearing the variance requests. So I was just going under that thought that it would be 2/3, but if it's more to the reconsideration, then it would be majority.
Yeah, we might have to research it because what we're reconsidering is our previous decision to grant the variance. So if the motion fails, I guess we need a motion to revoke the previous variance. And if that ties, I guess the variance would be granted because there was insufficient vote to, I don't know, we really need a parliamentarian. I don't know the answer. I shouldn't pretend like I do. I really don't. We need Robert's Rules of Order, I guess.
Which I do not have a copy with me. Let's see.
Well, would it be possible to postpone the vote until there are 9 members? That would at least prevent a tie.
It's up to the board. If someone wants to propose that as a motion. Mr. Boyd, Jenny, you need to.
I'd be happy to make a motion that we table this issue evening and then reschedule it for a vote when we have a full body.
I second that.
Will there be any additional information required from the applicants? Or
Not as part of my motion.
Okay, all right.
Okay, Ms. Working, if you could call the roll to see who would support that motion.
Okay. Mr. Ray?
Aye.
Ms. Lechner?
Aye.
Ms. Allison?
Aye.
Mr. Boykin?
Aye.
Mr. Freeman? Mr. Freeman?
Aye.
Mr. Goldstein?
Aye.
Mr. McConnell?
Nay.
And Mr. Nelson?
Aye.
Okay. That motion passes.
In the meantime, just purely as precatory, not mandatory language, perhaps the group speaking in opposition could elect a spokesperson. Maybe Melinda Kelley might be a good person, and maybe she and Mr. Gaskins could communicate with one another and see if they could make some headway at reaching an accord. They're not required to, of course.
I like your suggestion, Mr. Goldstein. If the applicant could volunteer to move the road, that would expedite this process.
Mm-hmm. All right. Well, we have many more cases to go, so we're wrapping this one up.
I think we're ready for the next case.
Okay.
Okay, Ms. Working, if you would present the next case for us.
The next case is going to be presented by Joshua Downey. So Josh.
Ready? All right. This is BZA case 7. BZA 0720000410. The applicant and property owner, Don Mockley, is requesting a special exception to establish a short-term rental, extended home rental in the low-density housing manufacturing subdivision, MHS zoning district at 2014 Covey Lane, TMS number 33107000017 on James Island in Charleston County. The subject property and properties to the north, south, east, and west are located in the low-density housing manufacturing housing subdivision, MHS zoning district. The property contains a 1,230 square foot, one-story modular home with 2 bedrooms that was constructed in 1984 per Charleston County records. Currently, the subject property is in the site plan review process, ZSPR 1219-00428 for the proposed use. The applicant's site STR property zoning application states that a maximum of 2 bedrooms will be rented and 4 parking spaces will be provided as shown on the proposed site plan, and the property will be owner occupied. Staff conducted a site visit on September 15th, 2020. The Board of Zoning Appeals may approve with conditions or deny BZA case 0720000410 special exception request to establish a short-term rental, extended home rental in the low-density housing manufacturing subdivision, MHS at 2014 Covey Lane, TMS number 33107000017 on James Island in Charleston County, based on the BZA's fact finding, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, the board should consider the following conditions recommended by staff. Number 1, the zoning prior to a zoning permit approval, the applicant shall complete the site plan review process. Number 2, the use shall comply with all requirements in Article 6.8. And number 3, the property owner shall be responsible for ensuring the tenants comply with the Charleston County noise ordinance. That is the proposed site plan. And any questions for staff? Any questions? Back on you, Mr. Ray.
Mr. Ray?
I'm sorry, we were having a discussion. I apologize. So is the applicant present? Of course, the applicant's present. Is the applicant present? Ms. Working, could you pull the applicant up?
Yes, Mr. Moxley? Can you hear us? I'm asking him to unmute.
Please, sir, there you go.
Hello.
Thank you. Would you? Good evening, sir. Would you please tell this board why we should approve your case?
Yeah.
Oh, I'm sorry. You need to be sworn in first.
Please raise your right hand. I will say the oath, and you will say, "I do. I swear to tell the truth and nothing but the truth. I do."
I do.
Okay. And if you can please just state your full name and address for the record, and then why the board should approve your application.
Don Moxley, 2014 Covey Lane, Charleston.
Okay, why should the board approve your application?
I've lived on this property for 30 years and I find that I can no longer afford to, I need help. Presently, I'm doing limited short-term rental. I've never had any problems. And I don't know if anybody is speaking out against me, but I need this extra rental just to pay my mortgage.
Yeah, and we don't have any speakers in favor or in opposition for this case. And we didn't receive any letters as well.
Yeah, it's not, most of my neighbors know that I do it, and like there's never been any problem.
Okay. Thank you, Mr. Moxley. Do we have anyone that has a question of Mr. Moxley? Does any board member have a question for Mr. Moxley? Thank you so very much, sir, for your time.
Thank you.
Yes, sir. Does anyone have any question of staff regarding this case? I see no hands. If not, this case is closed to public. At this time, we need a motion to either approve or deny this application. Ms. Lettner, I see.
Thank you. In regard to case BZA 0720000410, I make a motion that we vote to approve the special exception based on the following findings of facts. For criteria 1, it is consistent with the recommendations contained in the Charleston County Comprehensive Plan. Criteria 2, it is compatible with existing uses in the vicinity and will not adversely affect the general welfare or character of the immediate community. Criteria 3, adequate provision is made for such items as setbacks and buffering to protect adjacent properties from adverse influence of the proposed use. Criteria 4, where applicable, will be developed in a way that will preserve and incorporate any important natural features. Criteria 5, it complies with all applicable rules, regulations, laws, and standards of this ordinance. And criteria 6, vehicular traffic and pedestrian movement on adjacent roads will not be hindered or endangered. I'd also like to add that the 3 conditions recommended by staff also be included in this motion.
Thank you so very much, Ms. Lettner. At this time, do we have a second?
I'll second it.
Mr. Bork, the chair recognizes your second. Thank you so very much, sir. Ms. Working, at this time, could you call the roll for the vote?
Yes, Mr. Ray?
Aye.
Ms. Lettner?
Aye.
Ms. Allison?
Aye.
Mr. Boykin?
Aye.
Mr. Freeman?
Aye.
Mr. Goldstein? Mr. Goldstein? He went. Mr. McConnell?
Aye.
Mr. Nelson?
Aye.
And Mr. Goldstein?
Aye. Sorry, it muted me for some reason. I don't know what happened.
Okay. So that was a unanimous vote for approval with 3 conditions.
So, Mr. Moxley, thank you for coming to meet with the board tonight. Within 10 working days, you will receive a certified letter stating the next phase, the next steps that you need to take in this process. Once again, this board congratulates you on your approval. Ms. Working, the next case that we have available, unavailable, is, thank you. Would you present the next case? Case BZA 07-20-00411. And I think that's being done by Mr. Who's that being done by? Who's presenting that one, Ms. Working?
I'm presenting that one.
Okay, thank you.
Okay, yeah, BZA 07-20-00411. The applicant is HLA Nick Allports, and the property owner is Paul H. Spites. The property location is 2690 Swigert Boulevard, Johns Island. TMS number 311-000050, and it's in the industrial zoning district. The request is for a variance to reduce the required 35-foot OCRM critical line buffer for encroachments, disturbances for a proposed dry stack boat storage facility. The Charleston County Zoning and Land Development Regulations, ZELDR, Chapter 9 Development Standards, Article 9.7, Wetlands, Waterways, and OCRM critical lines, Section 9.71, requires a 35-foot OCRM critical line buffer in the industrial zoning district, and Section 9.72, Prohibited Activities, lists those activities that are prohibited in the buffer area. This is a zoomed in aerial of the site, a zoomed out aerial. And this is a picture of the existing facility that will be demolished and replaced. And again, the existing building to be demolished. Some views of the Sona River and the approval criteria. So staff, we believe it meets criteria 1, 2, 3, and 5. We said that it may meet criteria 4, 6, and 7. And then if you can go down the site plan, they did provide the site, and we're recommending with conditions, sorry, the applicant property owner shall complete the site plan review process. So if you decide to, you can approve conditions or deny the request, but if you do approve it, we're just suggesting that condition. And then I think the next slide is the site plan that they're proposing, and then they provided plats as well. Do you have any questions for me?
Does anyone have questions of staff? Okay. I see no hands. Very good. Is the applicant present?
Okay.
Hello.
Is this Andrew Todd Burke?
Yes, ma'am.
Okay. Hi, Andrew. If you can please raise your right hand, I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth I do.
I do.
Thank you. Okay, now just state your full name and address for the record.
My name is Andrew Todd Burke, and the address at HLA is 29A Linebach Drive in Charleston. Thank you, board and staff, for hearing this presentation. So what we are asking for is a critical line buffer encroachment for the construction of a boat dry stack facility, which is a boat storage facility. This is an approved use per Charleston County. We've already secured that. We also have OCRM permits and DHEC permits as well for the construction of this facility. And what we will be doing per the picture that you saw, there's an existing building that will be removed and a dry stack facility will be put in its place. And Edgar, I'm not sure if you could put on the site plan just for reference as I'm speaking. But the current conditions of the buffer, as you can see on some of the pictures in here, some of it is existing marsh grass and planted, but the majority of the buffer in this area has been maintained as turf. And as part of our proposal, what we would like to do is reestablish native vegetation in this area to enhance the buffer that is already existing. Also, as part of our water quality enhancement proposal for this project, we will be installing a manufactured treatment device where all of the runoff from the proposed parking lot and dry stack facility will run through this manufactured treatment device to improve the water quality before it is discharged. And that is the long and short of it. We would like to put this facility in and also improve what the current buffer is, as well as improve the water quality running off of the site to what it is currently. And I am here for any questions you may have.
Thank you so very much, sir, for your testimony. Do we have any questions of the applicant?
One short one.
Mr. Gold.
What does HLA stand for?
Hoffman Lester Associates.
Okay, I just wondered.
And I would like to add one more thing, is that the next two variances on the list for this project, we would like to withdraw them from consideration of tonight and solely focused on this variance.
Thank you very much, sir. Anyone else? We will take that in consideration. Does anyone else have any questions of the applicant? I see no hands. Okay. Any questions of staff at this time? Does any board member have a question of staff? Okay. Ms. Working, do we have anybody in opposition?
So we have a couple other speakers in support, but
I thought he was the only one.
Andrew, is anyone else from your group speaking now?
Not at this time.
Okay. And then there was a Milo Hinkle that was that requested to speak in support, but I don't see him on here, so I guess we'll have to skip that. We do have one speaker signed up for opposition.
Thank you, Ms. Working. Could that person please be brought forward?
Yes. Mr. Thomas Road, can you hear me?
Can you hear me?
Yes, sir. Can you please raise your right hand? I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Okay, thank you. And please state your full name and address for the record.
My name is Thomas Road of Thurman, Kirshner, and Timms. My address is 15 Middle Atlantic Wharf in Charleston. Thank you, members of the board, for hearing from us tonight. As you can probably see in your materials, we submitted a letter, brief letter to the board outlining some concerns and objections we had regarding this application, as well as the two applications that came along with this. The primary concern that was raised in that letter obviously related to issues regarding the ownership of the land on which the variance was being requested. I suspect that that is probably the reason why the latter two variances were withdrawn. So I won't belabor that point, but that issue does affect to some degree the variance that's still at issue in this case regarding setbacks from the OCRM line, particularly with regard to the needed silt fences for the access of ingress and egress to the existing easement as it is now. And that issue is probably most easily seen by taking a look at the bottom left tile on the site plan that's been submitted. And it shows there just that silt fence variance sort of encroaching into the neighboring parcel. So to that extent, we would stand on the points we made in that letter regarding the lack of standing and the inability of the applicant to request the variances that are being made here. A couple other items to just point out. One concerning the, as the staff recommended, this requested variance may meet the criteria of 4, 5, and 6, or 4, 5, 6, and 7, I think is how I understood how it was presented. To just hit on a couple of those notes, one of those is the increase in traffic, right? So as we set forth in the letter, the sole means of ingress and egress from Johns Island to this marina is a private easement that the applicant does not own, that is owned by the neighboring landowner, that is not part of this application. It sort of summarily states that traffic will not increase, but they have obviously acknowledged that they're going to be adding a 200 unit dry stack. That sort of dovetails into the next issue of the need for the applicant to request this variance. Nothing has sort of been presented as to why they need 200 dry stacks out there and why a request for 50 or 75 or 100, which possibly could fit within the OCRM critical lines and wouldn't need the variance, is not a viable solution. The same for issues related to parking, but again, those have been withdrawn. And just to go down the rest of this list, the result of the variance not being of the applicant's own creating item or criteria number 6. Again, here we would just like to point out that this parcel is nearly 9¼ acres. They're attempting to put the dry stack, at least based on their site proposal, within this sort of very confined space, which appears to be what is driving the need for the OCRM setback variance. And I don't see anything in here as to why the dry stack can't be located on the remaining, sort of 7 acres of land that exist here without the need to encroach upon the OCRM critical line.
All right. Thank you so very much, Mr. Rhodes, for your comments. Do we have any other questions? Do we have any questions for Mr. Thomas Rhodes? Mr. Goldstein.
I do not see your letter, Mr. Road. It's not in my materials. This is the first I'm hearing of it.
I'll be happy to shoot you a copy by email if that would be helpful, or we submitted it last week.
Yeah, those were the materials I forwarded to you on Friday. It met the Friday deadline for Friday.
Well, I printed a bunch of stuff, but it was all related to
notes.
There were 4 or 5 PDFs attached to that email.
that's operator error. That's on me then. Well, how material is your letter that you sent us to the one variance that is now pending?
Well, obviously, Mr. Goldstein, I think I wouldn't say it's not material, or I wouldn't have submitted it.
No, I understand.
Yeah, I think that it is material. I think it outlines some of the points that I've made tonight. I think I've made some additional points tonight. Obviously, a lot of that letter focuses on the issues that were requested as a whole, meaning the three sort of there were 3 cases that sort of came up together. So that letter is sort of addressed in that capacity, addressing all of them. But I think that it elaborates perhaps just a little bit on the points that I've made tonight. So in that sense, it's material. But other than that, it's really just a function of pointing out some issues that I believe that they have simply failed to carry their burden on under Article 3 or Section 3.
And your client is an adjoining property owner?
My client is are 2 members of a partnership which owns essentially the balance of Clark's Island, which is the island that that the applicant parcel is on.
But do your clients agree that the proposed use is a much less intensive use of the property as to what has been there in the past? Would they agree with that?
I don't know that they would agree with that, Mr. Goldstein. I think that what my question to you would be is, what do you mean by intensive use of property?
Well, we can ask the applicant on rebuttal, but my understanding is that this property has traditionally been used as a heavy industrial marine fabrication plant where they were doing sandblasting and marine repair and that really kind of heavy stuff that degrades the water, is my understanding, but I'll ask him on rebuttal for clarification.
Yeah, and I think that I don't want to represent one way or another because I'm not entirely familiar with the full scope of work that is done out there. I do know that it is an industrial zone parcel. I do know it functions as essentially as a boat yard. I do suspect that they do boat repair. Seems pretty apparent from the photos that that's what they do.
Yeah.
As far as intensive use, and whether or not this will increase or decrease the intensive use, I think that you may be correct in that the use type will change. But as far as how that intensive use affects the neighboring landowners by adding what is essentially 200 new tenants on an island right now that has 1, is pretty substantial. Particularly when those 200 new tenants have to traverse a road and a bridge that is all owned by the partnership that my clients are members of and have an obligation to maintain. And there's been no discussion, and we've been made aware of no communication between them as far as any agreement as to how to deal with issues like that. You know, they're going to clearly be associated with some really intensive increase in traffic.
Is this something that your clients would prefer that we vote on tonight, or would you prefer an opportunity to sit down and discuss it with the applicant to see if you could reach some common ground?
I would be remiss to say that I wouldn't welcome the opportunity to sit down with them.
You would or would
also,
not?
I wouldn't turn down the opportunity to sit down with them, but I will, you know, in all candor to the board, these folks are not strangers to one another, and there are other issues going on out there as far as the use of this land. well, let me back up. Not this particular applicant land, but the island as a whole. Certainly, we would welcome the opportunity to sit down and discuss this further with them and perhaps come to an agreement. So to that extent, I'll defer to the board on how it wants to proceed.
Okay, thank you, sir.
All right. Thank you so very much. And does anyone else have any questions or comments? I see none. So at this time, we do have the right of rebuttal for the applicant. Ms. Working, can you please bring up the applicant and see if he would like to have his moment to rebut what was said?
Yes, I'd like to give my time to Cody Leinhardt for the rebuttal, please.
He would need to swear in. Ms. Working would have to swear him in first.
Yeah, I'm gonna get him on. Okay, Cody, can you please raise your right hand? I will say the oath and you will say, I do. I swear to tell the truth and nothing but the truth. I do. Cody? Yeah.
You there?
Is this Cody?
He is now.
It is. It
Okay.
is.
I was trying to swear you in. Can you please?
And I said I do.
Oh, you did. Okay. Thank you. And can you please state your full name and current address for the record?
Yes, sure. My name is Cody Leinhardt. I am with Leinhardt Law Firm. My address is 78 Ashley Point Drive, Suite 103, Charleston, South Carolina. And I would just submit that I am counsel for the applicant with regard to this property and the issues in front of this board, and would like to respond to a couple of things raised by Mr. Rode in opposition to this. With regard to the road and access to the parcel at issue for the proposed dry stack, the road is subject to an ingress egress easement that was reserved for the benefit of the dominant parcel, which happens to be the parcel where the dry stack is to be located. That was reserved many years ago, has been in operation as a commercial access road for the operations on the parcel at issue. And pursuant to that reservation of easement that I believe dates back, and I apologize for not having it in front of me, to the 60s. The applicant is responsible for the maintenance and upkeep of that road and bridge. That is the main point, Swigert Boulevard, to the property. With regard to the issues before the board, the applicant is merely seeking some encroachment into the 35-foot OCRM buffer to allow for continuation of its existing water-dependent use. As Mr. Goldstein correctly pointed out earlier, the operations at the site are ongoing, marine-related. There are access points along the parcel at issue to access the Stono River. The applicant's plan is to, would require it to encroach into the 35-foot setback buffer as part of the dry stack operation for the launching of boats. It would be remiss to think that you could have a dry stack operation and have no access to the water. It would be impossible to operate a dry stack without water access. It is a water-dependent activity per OCRM regulations. It's a water-dependent activity per federal regulation. It's been approved at the federal and state level for these operations. The request of the applicant is merely to allow for that access point, to allow boats to be launched from a permitted launch pier, and to have some encroachment in the 35-foot buffer to allow for enhancement of the buffer. Currently, the operations at the site are industrial, heavy industrial, as has been pointed out, and the applicant proposes a significant visual as well as spatial as well as water quality improvement to runoff stormwater from the site through these encroachments to allow for not only the plantings as well as stormwater control structures. So that's really the issue here. The overriding arguments against this with regard to the disputes or ongoing discussions between the applicant and the opposing parties are beyond the scope of the application before the board. Those are issues related to property issues that unfortunately haven't been resolved to date, but continue to be on the table between the parties.
Thank you so very much, sir, for your testimony. Does anyone have any questions, Mr. Leinhart?
Just
Mr.
one,
Goldstein?
very short. I'm asking you the same question I asked Mr. Rowe. Do you want us to address this tonight, or do you want an opportunity to sit down and discuss with him his client's concerns? What's your preference?
Thank you, Mr. Goldstein. I think my clients very much would prefer that the board make a decision on this one variance request. There has been, and I will admit that I have not been part of those discussions, but other counsel for the applicant has been numerous and ongoing discussions related to other matters between these parties. And this just happens to be an issue that it appears they've chosen to make it a bone of contention.
Okay. Thank you, sir.
Yes, sir.
Thank you both. Does anyone have any questions of staff? First, before I go any further, we don't have anyone else, do we, Ms. Workin, to speak in opposition?
No, that's it.
Okay.
Ms.
Does
Workin,
anyone
I'm
have
sorry.
any?
This is Thomas Redd. I lost the ability to raise my hand, and I was going to try to do a hand raise if it was possible.
I mean, we already took rebuttal from the applicant, so we don't take speakers after that.
Yeah. So at this time, does any board member have any questions of staff? Hearing none or seeing none. At this time, we need a motion for this application. Do we have anyone that would like to make a motion for this application? Mr. Goldstein, Chair recognizes you, sir.
I'll tackle it because it seems pretty easy to me, but maybe not. I'm going to make a motion that the variance request for encroachment in the OCRM be approved. And I'll say at the outset, I honestly don't see how we could deny it. If they got an OCRM permit for a water dependent use, I think that pretty preempts us. But anyway, I find that the evidence is uncontradicted that there are extraordinary and exceptional conditions pertaining to the particular piece of property. And so they meet 3-10-6 subsection 1. As for subsection 2, the conditions only apply to this particular piece of property. So they, again, the uncontradicted evidence shows that they meet criteria 2. As for criteria 3, the application of the ordinance would effectively prohibit unreasonable, restrict the utilization of the property. It's an industrial zone, and I don't know how in the world you could operate any kind of business as a water dependent use without having access to the water. So I think they meet criteria 3. As for criteria 4, granting the variance will not be a substantial detriment. Again, I point to the permits they've already secured from OCRM and the Corps of Army Engineers to validate that point. So I think they meet criteria 4. As for criteria 5, the variance clearly allows a use that is specifically permitted. And as Mr. Leinhart pointed out, the proposed use is much less intrusive than the current use. So I think they meet criteria 5. As for criteria 6, the need for the variance is not the result of the applicant's own actions. the need for the variances to have access to the water to operate a dry stack marina, which is much more environmentally sound than a marina located in the water. So I think the applicant should be applauded for that. And criteria 7, granting the variance would not be in any conflict with the comprehensive plan. Obviously, I'm going to incorporate staff's recommendation that the applicant shall complete the site plan review process, which they would be required to do under any circumstance. So for those reasons, I make a motion that the variance be granted.
Very good. Thank you, Mr. Goldstein. Did I see Mr. Nelson's hand go up for a second? Yes. Before I... Okay. Thank you, Mr. Nelson. So we have a motion that has been properly moved in second. At this time, it's working. Would you please call the roll?
Hey, Mr.
For
Ray.
the vote? Aye.
Ms. Lechner? Ms. Allison?
Aye.
Mr. Boykin?
Aye.
Mr. Freeman?
Aye.
Mr. Goldstein?
Aye.
Mr. McConnell? Mr. McConnell?
Say it again. Aye.
Thank you. And Mr. Nelson?
Aye.
Okay, so it's unanimous to approve with the one condition.
Congratulations, sir, on your approval. Within 10 working days, you will receive letter and notification from this board stating, or staff, I should say, stating your next step in the process. We do thank you for your time to bring this application before us. Ms. Working, at this time, it's 7:38. I'd like to make a motion that we take a 10-minute break and resume in 10 minutes. Any questions? So if we can...
I don't think you need a motion. You're the chairman. You get to do what you want.
I was trying to be nice about it, but yeah, thank you. So at this time, we'll take a 10-minute break, and we will resume at 7:48. So very much, Ms. Letton. That was well done. Do we have a second? Mr. Goldstein, we recognize you as the second. Thank you so very much. At this time, ladies and gentlemen of the board, we have properly moved. We have a motion that has been properly seconded. We need to, at this time, bring it to a vote. At this time, Ms. Working, could you please call the roll for the vote?
Yes, Mr. Ray?
Aye.
Ms. Lechner?
Aye.
Ms. Allison?
Aye.
Mr. Boykin?
Aye.
Mr. Freeman?
Aye.
Mr. Goldstein?
Aye.
Mr. McConnell?
Aye.
And Mr. Nelson?
Aye.
Okay, so that's unanimous approval with one condition for BZA 0820000414.
Ms. Waring and Mr. Waring, we thank you for coming and meeting with us tonight by means of Zoom. And within 10 days, you will get a written notification by certified mail telling you the next step in the process. Once again, congratulations.
Thank you.
So the next case we have will be done by Mr. Joshua Downing. It'll be case BZA 08-20-00416.
All right. The applicant and property owners Susan D. Jackson and Marion Jackson are requesting a special exception to establish a short-term rental extended home rental in the single-family R4 zoning district at 2156 Gulf Drive, TMS number 34306000018 on James Island in Charleston County. The subject property and properties to the north, south, to the north, east, and west are located in the single-family R4 zoning district. The property to the south is within the jurisdiction of the city of Charleston. The property contains a 1967 square foot single family home with 3 bedrooms and was constructed in 1950. A 504 square foot accessory dwelling unit with 1 bedroom was also constructed in 1950 per Charleston County records. Currently, the subject property is in site plan review process ZSPR 0420000468 for the proposed use. The applicant STR property zoning permit application states that the accessory dwelling unit over the detached garage will be rented with 5 parking spaces provided as shown on the proposed site plan, and the property will be non-owner occupied. Staff conducted a site visit on September the 15th, 2020. The Board of Zoning Appeals may approve with conditions, or deny BZA case 0820001416 special exception request to establish a short-term rental STR, extended home rental EHR in the single-family R4 zoning district at 2156 Gulf Avenue, TMS number 34306000018 on James Island in Charleston County, based on the BZA fact finding, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, the board should consider the following recommendations by staff. Number 1, prior to permit approval, the applicant should complete the site plan review process. Number 2, the use shall comply with all requirements of Article 6.8. And number 3, the property owner shall be responsible for ensuring the tenants comply with the Charleston County North Ordinance. Next slide. That is the site plan of the property. That is the plat. And are there any questions of staff?
Does anyone have any questions of staff, as Mr. Downey mentioned? No? Ms. Working, is the applicant available?
Yes, and her name is Susan Jackson. Hey, Susan, I'm going to ask you to unmute, please.
Okay, I'm here.
Okay, great. Can you please raise your right hand? I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Thank you. And then just state your full name and address for the record and speak to the board about your case.
Sure. My name is Susan Jackson. I live at 2182 Edisto Avenue in Riverland Terrace neighborhood on James Island. I thank you for, this is your patience in hearing our case. Yeah, we would like to, get the permit to do the short-term rental, extended home rental in the apartment over the garage over there at Gulfview Drive.
Okay, Ms. Jackson, is that it?
That's it.
Okay. Okay. Does any board member have a question of Ms. Jackson? Ms. Allison? No? Oh, okay. Anyone else? Well, Ms. Jackson, we thank you for your testimony tonight. Ms. Workin, do we have anyone else to speak in support?
No, we do not have anyone else to speak in support or in opposition.
Okay. Well, thank you. So at this time, I'll close it to public comment. And if we don't have any other questions of staff, I'd like to entertain a vote or a motion.
Yeah. Hello?
All right. Wait.
Yeah. I make a motion.
I thought the hands go at the same time. Mr. Freeman, go right ahead.
Okay, I make a motion that we approve case BZA 0820000416. According to criteria 1, is consistent with the recommendation contained in the Charleston County Comprehensive Plan and the character of the underlying zoning district as indicated in the zoning district description. Criteria number 2 is compatible with existing uses in the vicinity and will not adversely affect the general welfare or character of the immediate community. Criteria number 3, the project is currently in the site plan review process to ensure compliance with the ordinance. Parking on the site complies with CDLR, Article 9.3, Section 9.32.2, off-street parking schedule. Off-street parking. Also, criteria 4, the proposal preserves important natural features. No changes are proposed on the site. Criteria number 5, complies with the applicable rules, regulation laws, and standards of the ordinance, including but not limited to any use, conditions, zoning district standards, or site plan review requirements of the ordinance. Criteria number 6, vehicular traffic and pedestrian movement may increase slightly when the home is rented. However, adjacent roads should not be hindered or endangered. In addition, we'd like to have the staff's recommendation with the prior to zoning permit approval. The applicant shall complete the site plan review process. Number 2, the use shall comply with all requirements of Article 6.8. And number 3, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance.
Very good, Mr. Freeman, thank you. Do we have a second? Mr. Nelson, I see your hand. Thank you, sir. So we have a motion that has been properly moved and second. Ms. Workin, would you please call the roll for the vote?
Okay. Mr. Ray?
Aye.
Ms. Lechner?
Aye.
Ms. Allison?
Aye.
Mr. Boykin?
Aye.
Mr. Freeman?
Aye.
Mr. Goldstein?
Aye.
Mr. McConnell?
Aye.
And Mr. Nelson?
Aye.
And so that's unanimous approval with the 3 conditions.
So, Ms. Jackson, we thank you for meeting with us tonight. Within 10 working days, you will get a certified letter from staff telling you exactly what the next steps are in this process. Once again, congratulations on your accomplishment tonight.
Thank you very much.
Thank you.
Sorry, I'm keeping her on because she's also the applicant for the next case.
I'm sorry, say again?
I have her on and she's muted, but she's the applicant for the next case as well. So
correct.
Yes.
So the next case, which is BZA 08-20-00417, and that will be done by Mr. Downing again, please.
All right. The applicant and property owners, Susan D. Jackson and Marion Jackson, are requesting to establish a short-term rental, extended home rental in the single-family R4 zoning district at 2182A Edisto Avenue, TMS number 34306000124 on James Island in Charleston County. The subject property and properties to the north, south, east, and west are located in the single-family R4 zoning district. The property contains a 1,092 square foot home with 3 bedrooms that was constructed in 1955 and a 400 square foot accessory dwelling unit that was constructed in 1950 per Charleston County records. Currently, the subject property is in the site plan review process ZSPR 0420000464 for the proposed use. The applicant STR property zoning permit application states that the accessory dwelling unit over the detached garage will be rented a maximum of 1 bedroom and 5 parking spaces will be provided as shown on the proposed site plan. And the property will be non-owner occupied. Staff conducted a site visit on September 15th, 2020. The Board of Zoning Appeals may approve with conditions or deny BZA case 08-2000-417 Special exception request to establish a short-term rental, extended home rental in the single-family R4 zoning district at 2182A Edisto Avenue, TMS number 34306000124 on James Island in Charleston County, based on the BZA's fact finding, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, the board should consider the following recommendations by staff. Number one, prior to the zoning permits approval, the applicant should complete the site plan review process. Number two, the use shall comply with all requirements in Article 6.8. And number three, the property owner shall be responsible for ensuring the tenants comply with Charleston County's noise ordinance. Next slide, that's the site plan and the plat. And there is something by staff that the board should consider for review. In their staff review, it says the property will be owner occupied, and that was a mistake on staff's behalf. The property will be non-owner occupied.
Thank you, Mr. Downey.
Yes, sir.
Does anyone on the board have a question of staff? Once again, the applicant still should be available here for comment. Ms. Working, if you could just unmute Ms. Jackson, please.
I'm here.
Okay, Ms. Jackson.
Yes, so shall I state my name and address again, or?
Sure, that'd be good.
Okay, so I'm Susan Jackson. I live at the single family residence at 2182 Edisto Avenue. Our request is for the accessory dwelling unit, which is an apartment over the garage. We do live in the single family home in front, and I will say we've enjoyed having that space for family to come, and would like to continue to have the flexibility for friends and family to come stay with us. It's essentially our guest house per se, and so I'm having the same request. I would love the approval to do the extended short-term rental. I did read the comments. I think there was 2 letters in opposition, and my response would be, it is not the single family home. It is the 400 or some square foot apartment over the garage. And so, we do live in the main house in the front.
Thank you, Ms. Jackson. Does any board member have a question of Ms. Jackson?
Yeah, I got one short one.
Mr. Goldstein.
Ms. Jackson, how is it that you find every cool garage apartment in Charleston?
That would be to my husband's credit. He found these places and wanted to purchase them, and I said there's no way, because we'll be strapped and I don't want to live paycheck to paycheck, but somehow we have pulled it off thus far, and hopefully this will help, and we'll have a little more financial stability and flexibility.
He sounds like a keeper.
Oh, he is.
Okay.
Don't get me started.
Very good. Does anyone else have any questions of the applicant? I see none. Thank you so very much, Ms. Jackson.
Yeah, and
Ms. Workin, do we have anyone to speak in favor or opposition?
We do not, but as you stated, there were 2 letters that you received on Friday. One was from Robert McKay, strongly objecting to the request, and he's at 680 Highwood Circle. And the other one didn't seem to be an outright rejection, but it's from Linda Wilson at 2167 Medway Road.
Thank you so very much, Ms. Working.
Okay.
So no one else, I would assume, has any more questions of staff? At this point, this case is closed to the public and is now open and available for a motion to either approve or deny. Does anyone Mr. Boykin, thank you so very much, sir.
I'll be happy to make a motion that in BZA case 08-20-00417 that I move that we approve the application for special exception. I find that based upon staff review and the applicant's testimony and information provided, that it meets all 6 of the criteria as stated, and that I would also include the 3 conditions that staff has put in place. So I'm moving.
Unfortunately, Mr. Boykin, you got to go through all 6.
That's fine. That's fine. Condition 1, I find it is consistent with recommendations contained in Charleston County Comprehensive Plan and the character of the underlying zoning district as indicated in the zoning district description. Number 2, that it is compatible with existing uses in the vicinity and will not adversely affect general welfare or character of the immediate community. Number 3, that adequate provision is made for such items as setbacks, buffering, fences, and landscaping to protect adjacent properties from possible adverse influence of proposed use, such as noise, vibration, dust, glare, odor, traffic congestion, and similar factors. That it meets criteria 4, where applicable, will be developed in a way that will preserve and incorporate any important natural features. That it meets condition 5, that it complies with all applicable rules, regulations, laws, and standards of this ordinance, including but not limited to any use conditions, zoning district standards, or site plan review requirements of this ordinance. And finally, that it meets criteria 6, that vehicular traffic and pedestrian movement on adjacent roads shall not be hindered or endangered.
And does that conclude all other 3, the other 3 conditions, Mr. Boykin?
It does. I mean, I can read those as well. Number 1, prior to zoning permit approval, the applicant shall complete the site plan review process. Number 2, the use shall comply with all requirements of Article 6.8. And number 3, the property owner shall be responsible for ensuring the tenants comply with the Charleston County noise ordinance.
Mr. Boykin, thank you for that. Does anyone on the board care to give us a second? Do we have a second? Ms. Lettner. Oh, we got a couple of seconds going on, but I saw Ms. Lettner's hand first. Thank you so very much, Ms. Lettner. At this time, we have a motion that have been properly moved and second. Ms. Working, would you please call the roll for the vote?
Sure. Mr. Ray?
Aye.
Ms. Lechner?
Aye.
Ms. Allison? Ms. Allison?
Aye.
Okay. Mr. Boykin?
Aye.
Mr. Freeman?
Aye.
Mr. Goldstein?
Aye.
Mr. McConnell?
Aye.
And Mr. Nelson?
Aye.
Okay, so that's unanimous approval with the 3 conditions.
Thank you, Ms. Working. Ms. Jackson, congratulations. Once again, within 10 working days, the Charleston County Board staff will send you out a letter, certified mail, letting you know the next steps and the process. We thank you once again for submitting your application, and congratulations.
Sure, thank you for your time and attention.
Thank you. Finally tonight, board, we have one more case on the docket. And if I can turn to it fast enough. Yep. So our very last case for tonight is case BZA 08-20-00, -00418. And that will be presented by Mr. Edgar Sada.
Yes, sir. I think before I get started, Mr. Freeman is going to recuse himself from this case. So, Mr. Freeman, would you like to make a statement?
Yes, I'd like to recuse myself from this case here.
Thank you, Mr. Freeman.
Thank you, sir. Thank you, Mr. Freeman.
Thank you, Mr. Freeman. This is case BZA 08-20-00418. Travis Randall, the applicant, on behalf of the property owner Jana Wright, is requesting a variance to encroach upon the protected area of a 43-inch diameter breast height ground live oak tree in excess of 25% for a proposed 30-foot gravel ingress, egress, and general utility easement in order to access TMS number 203-00000012. The grand tree is located on 3373 Habitat Boulevard. That's TMS number 203-00000092 on Johns Island. The subject property and adjacent properties are located in the agricultural residential AGR zoning district. And to save some time, I'm going to skip over the Zeldar requirements, but I would like to say something about the history of this property. The applicant, Travis Randall, purchased property TMS number 203-000012 from Thomas D. Easton on October 8th, 2019. That's on deed book 0828, page 730. This property was issued a court-ordered easement, an easement by necessity, on March 15, 2016. That's on deed book 0542, page 908. If this easement were to be built, it would traverse through 4 properties. Those are TMS number 203-000011 and 117, 058, and 10 in order to gain access to Betsy Harrison Parkway. This easement is not currently an established travelway. An easement agreement was reached between Thomas D. Easton and Jana Wright on April 1st, 2019. That's deed book 0788, page 430, giving the property access to Habitat Boulevard. Staff conducted a site visit on the subject property on September 15, 2020. This is the location of the easement, along with the grand tree, subject property, 43-inch diameter breast height ground level oak. And we find that it meets all criteria and it may meet criteria 1 and 2. And if the board decides to approve this application, the board should consider the following condition. If the requested tree dies within 3 years of the construction of the proposed easement, the applicant shall mitigate the DBH of the tree by either A, submitting a mitigation plan for review and approval, indicating the installation of a canopy tree no smaller than 2.5 inches in caliper equaling inch per inch replacement. B, by depositing funds into the Charleston County Tree Fund as described in section 9.4.6 of the Charleston County Zoning and Land Development Regulations. Or C, a combination of both A and B. The alleged mitigation shall be in place prior to its removal. Is there any questions of staff? I'm sorry, here's the site plan. This is the plot for Jana Wright's property. This is the plot for Mr. Randall's property. Is there any questions of staff?
Thank you, Mr. Sada. Once again, a job very well done. Does anyone have a question of Mr. Sada again? No? Ms. Working, is the applicant available?
Yes, I'm going to get Travis Randall on. Okay, Travis, you there?
Hello, good evening.
Hi, can you please raise your right hand? I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do.
I do.
Okay, and then state your full name and address for the record.
Travis Randall, 1620 St. John's Drive, Johns Island. Good evening, everyone. Thank you for your time. I did not expect it to be 8:30 before we had this case come up, but I really do appreciate your time. This application came about after we purchased the property. We were under the assumption that everything was already established and completed. We went to get the survey recorded at the appropriate office. We had some issue about this tree, so that's what the application came about from. Just to make sure we do not want to remove the tree in any way or harm it. We really enjoy the tree being there, and we would appreciate the approval of this.
Thank you, Mr. Randall. Does anyone have a question for Mr. Randall at this time? I don't see any hands. Okay. Well, Mr. Randall, thank you so very much for your testimony. Ms. Workin, do we have anyone else in support or in opposition of this application?
No, we do not.
No, we do not, and we didn't have any letters either.
Very good. Thank you both, Ms. Working and Mr. Sada. All right. At this time, we'll close this application to the public. And at this time, we'll entertain a motion, for this application. Does anyone care to do the last one for tonight?
I'll take a shot.
Very good, Mr. Nelson. Thank you so very much, sir.
All right, in the matter of case BZA 0820000418, I make a motion that we approve. Based upon, one, there are extraordinary and exceptional conditions pertaining to this particular piece of property. This particular request doesn't generally apply to other properties in the vicinity, given that it is a landlocked property. Number three, because of these conditions, the application of this ordinance to this particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property, and in fact may also cause the destruction of a different grand tree. Number four, the authorization of a variance will not be of substantial detriment to the adjacent property or to the public good, and the character of the zoning district will not be harmed by the granting of this variance. Number five, the Board of Zoning Appeals shall not grant a variance, the effect of which would allow the establishment of a use that is not otherwise permitted in the zoning district to extend physically a non-conforming use of land or to change the zoning district boundaries shown on the official zoning map. The fact that the property may be utilized more profitably should be a variance be granted, may not be considered grounds for a variance. This request meets that criterion. The need for a variance is not the result of the applicant's own action. And number seven, granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. Also recommend that we include the special condition recommended by county that if the requested tree dies within 3 years of construction of the proposed easement, the applicant shall mitigate the DBH of the tree by either A, submitting a mitigation plan for review and approval, indicating the installation of a canopy tree no smaller than 2 1/2 inches in caliper equaling inch per inch replacement. B, by depositing funds into the Charleston County Tree Fund as described in section 9.4.6 of the Charleston County Zoning and Land Development Regulations, or C, a combination of both A and B. The allotted mitigation shall be in place prior to its removal.
Thank you so very much, Mr. Nelson. Do we have a second? I'll second it. So very good. So we have a motion on the floor that has been properly moved and second. Ms. Working, would you please call the roll for the
Mr. Ray?
vote? Aye.
Ms. Lechner?
Aye.
Ms. Allison?
Aye.
Mr. Boykin?
Aye.
Mr. Goldstein?
Aye.
Mr. McConnell? McConnell?
Sorry. Say it again.
Aye.
Okay. And Mr. Nelson?
Aye.
Okay. Yeah, that was unanimous. Approval with the one condition.
Mr. Randall, congratulations on getting your application approved. Within 10 working days, you will get a certified letter from this board and this staff letting you know what the next step is for this process. Once again, congratulations and good night. Very good, board. I also just like to take a minute. That was the last case for tonight. Ladies and gentlemen, we thank you for your patience tonight and tolerance in getting through all this. This was with staff many waking nights and last 4.5 hours with me. So I appreciate it. I'd also like to say, Mr. Sada, we thank you for all your help, your time, and your energy that you spent helping this august body. I'd also like to give you just a moment to address this board. If you guys don't know already, tonight is Mr. Sada's last meeting with us. Mr. Sada?
I just want to say it was a pleasure working with all of you. And if I was halfway decent at my job, it's because I was coached to be so by Jennifer working. And I would like to, give her a hand. I think that our society does a good job at pointing out when people don't do a good job. And I just want to say, Jenny, you've done a great job with the BZA. I never met someone so dedicated to their work. And I appreciate working with you and working with all of you. And I'll be around in Charleston. Hopefully I'll see you guys again. Thank you.
Yeah, we're really gonna miss Edgar. He's been really great to work with, but we understand that he needs to spend the next couple months to finish his degree. So hopefully, and he can become a planner. So that's the goal. But we'll miss him, and hopefully, maybe he'll be back.
It's not at Clemson, is it?
No, it's the community planning and urban design graduate degree at College of Charleston.
Okay, as long as it's not at Clemson.
No, it's not there, but they have a good program as well.
That's offensive, Mr. Goldstein.
Don't care.
Yeah. I think we just have a couple more things.
Working.
See?
Yeah. So for November 2nd, we have 6 new cases. 1 is a variance case and the other 5 are special exceptions. We only have 1 STR though. I don't know, do you guys still like this format? I don't know if things are getting better. I mean, the whole White House has this COVID. What do you think? I don't know. I'm happy either way. I think however you guys want to proceed.
Well, if I can just join in with Edgar, I'm sorry he's leaving, but I join in with his complimentary remarks of you, Jenny. Without you, we could never pull this off in a million years. You do yeoman's work in putting this together and making it work, and you really should be commended for that.
Thank you.
I'll second that motion.
Thank you. So what are your thoughts? Do you guys lean more towards keeping this format, or do you want to try to meet in person, or? I mean,
I'm fine
if it's not,
format.
If this format is not too onerous for you, it seems to be working fine. We accomplish what we need to.
Yeah, I mean, one thing that's easier about it is that we don't have to worry about logistics if we get a big crowd. And that was always, we don't know if we're going to get a big crowd. At least now there's kind of procedure where you sign up, so we know how many people. But like when we open it up, the building up to the public, we could have 300, and we just don't know what to do with all those people if that happens.
Yeah, it would be
That's the biggest issue.
I mean, a couple of us are on the older side would be at a big, I know I'm doing an awful lot to keep socially distant to keep from dying. So I appreciate what you're doing for us. I really do.
Okay, well, I mean, my opinion is just as long as we're under, because we can only do virtual while we're under the emergency order. So I think we should maybe just keep doing it while we're under the order, and then once we're out, we could figure out how to go back to doing the in-person but socially distanced meetings. So this is easier in my opinion. I think Edgar agrees too.
I agree with you.
It's once we did the first one, it was easy. Okay. What's the next slide? I think there's training. Next one. Then we just have a couple more people that need to finish training. Mr. Freeman, you just need an hour and a half. And then I know Mr. Ray, you said you're signed up for some classes. And then Ms. Lechner, you just need to sign up for a couple classes. I'd like to get everyone done before December 18th. So I can then take that next week to get all the paperwork done for the year.
Well, I got a question.
Okay.
What happens in December? Do I have to still keep coming or am I done?
I don't think they appoint the new members until January, February. Like, I feel like in the past we've had sometimes been able to get the new members to start February, but definitely by March.
Okay.
Is that a good answer? But we're gonna miss you.
Yeah, right.
We will. Okay.
Okay. If that's it, if no one else has any other comments, I want to thank you all for coming and sitting in front of your computers tonight. This staff, once again, has done a phenomenal job. I thank each and every one of you for the work that you've done to make this august body look fantastic every day and each time we come before our public. So thank you again. If that's everything, I now I call this meeting adjourned. Thank you.
Thank you.
Bye. Good night.
Good night.
Good night.